Yes, my lord.
You're for the landlord.
Yes, my lord.
So you're for the landlord. You have not obtained the possession.
Yes, my lord.
Execution?
I have obtained the possession. Execution is done, my lord. Now they have,
Now it is their appeal. Okay.
my lord, this appeal is my appeal. They have succeeded in their first appeal. This is a second appeal, my lord. Now,
Now,
they
what
have,
interim order are you seeking in this appeal?
my lord, I have no stay application, my lord. Only the memo of
And that
appeal.
means there is no scope for any interim order.
My
The
lord,
matter will be heard out. Okay.
yes, my lord. My
After
lord,
the paper books, anyway, it will appear as to be mentioned.
my lord, kindly tomorrow, my lord.
Anyway, it
Kindly.
will appear. If the records are there, it will appear.
The matter is there in the lower court tomorrow, my lord. Kindly let it appear tomorrow.
You see, it is there. You have not prayed for any interim order. Have you prayed for stay of the proceedings before
Well,
the
there
trial
is no
court?
cause of action for which I can pray for us.
Oh, the appeal is to be heard out.
Yes,
There is
my
no
lord.
question of
My
any
lord,
stay
they
of
have
any proceedings.
Yes, my lord. After they have instituted this
So for that, you have to file any application for stay. Have you filed that? If you want,
No,
any,
my lord. This has arisen only 1 week back, my lord. We have been served with the notice, but no application has been served on us.
so you file. So let it appear as to be mentioned. If you want any interim order, file necessary application.
My lord,
Yes.
kindly tomorrow, my lord.
Anyway, you give the slip, it will appear. Yes.
It's a 2015 civil revision for inclusion of
Obliged,
the
my lord.
urgency is that the opposite party still raising the construction despite having a stay order.
No, interim order is there.
Yes.
So if the interim order is violated, you have a remedy under the law before the trial court itself.
The matter, my lord.
Anyway, give the slip.
My lord, may I
Another is up for application. 138 today in.
Wait, let the outside the list matter.
My lord, may I permitted to mention?
My lord, to be mentioned completion date and filing paper.
No, which year matter?
My lord, this is motor accident claim case.
Okay, motor accident claim case. No. Let it appear under the heading motor accident claim cases. Under the heading after.
To be mentioned.
No. The matter was fixed earlier or heard earlier.
Yes. But by other bench.
No. Before this bench, was it heard earlier?
No.
So let it appear under the heading hearing. No, under the heading hearing. If the court does not reach, then it will be fixed.
Your Lordship, one matter which was fixed on 25th June at 3 p.m. But your Lordship was not.
Anyway, give the slip, it will appear as to be mentioned.
Kindly may be permitted to mention that listed under the heading extension of interim order.
Anyway, to be mentioned. Serve notice upon the other side.
Annex 0.
My lord,
Yes.
may I permitted inclusion for the list application on my head?
Application, yes.
My lord, MSCC application kindly please.
Yes.
The claim case comes under hearing matter only upgradation for upgradation.
No, just outside the list be over, yes.
My lord, this is running in today's list.
Wait, outside the list first.
Application in connection with second appeal. Matter was mentioned earlier. There are 5 CAN. CAN number 5 is not traceable. Department is saying that CAN is not traceable, but I have the filing slip.
Anyway, you give it, it will let it appear under the heading application.
May I be permitted to mention these matters? These are railway matters from 2009 till 2022. Most of these matters have become infractuous. It may appear in the list as to be mentioned, my lord, any day.
Yes.
Your Honor, may I be permitted to allow the substitution application with SAT number 44?
Yes, give it.
Not a big to mention, not all inclusion for under the heading application.
Application, yes, give it.
Lordships kindly to mention the previous matters for ready for hearing.
Ready for hearing, yes, after 2 weeks it will appear. Hearing. Yes, outside list, any?
Yes, my lord, two applications for extension of time, my lord.
Yes.
Deposit check.
So extension of time to deposit. Yes, to be mentioned.
I'm grateful, my lord.
Yes, outside the list.
With regard to an item appearing before your lordship,
Yes.
in heading application, interim order has been expired and matter is not being
Just
taken up.
wait. Yes, outside the list, any other mentioning?
Substitution application, man.
Yes, give it.
I've got to mention. This appeal, my lord, appeared as fixed matter on 14th of July.
Okay, to be mentioned, thereafter
To be
date will be fixed.
I'm not the applications, not the investment.
Yes, application. Yes.
Appearing item number 138 under the heading hearing. I am praying for upgradation.
138 claim case hearing.
Yes.
You just wait. If the claim cases are not called on or if the matter is not reached, I shall fix a date. Just wait for 2 days. 138.
Item number 81, my lord. By this time, my lord, interim order expired. This matter has been heard extensively by your lordship.
No, when
Only-
will the order expire? Because application matters will be taken up.
No, this matter.
Either
is
tomorrow or
wrongly-
day after tomorrow,
My
application will
humble
be.
submission matter is appearing wrongly in the application heading because there are no pending applications. Applications were disposed of, matter was being heard, it was made part heard, and the date was fixed only, my lord, for to hand over the written notes of arguments. By this time, the interim order expired. Item number 81, your lordship can remember that matter. Tika, whether the.
Yes,
Tika-
yes, you are for the appellant.
I am for the appellate, my lord.
Acha, item number 81, record an order.
It was
Let
scheduled.
this matter appear under the heading to be mentioned on 22/7/2026. The interim order granted earlier stands extended for a period of 4 weeks or till further orders, whichever. Okay, let it appear as
Let
to
it
be
appear, my lord, we will then.
thereafter I
place it,
shall
my lord.
extend
Because I have informed
Yes.
my learned friend.
on 22/7/2026.
Lordship.
My case is it was said fixed for hearing on 7th May, but court did not sit on that day. Thereafter, I mentioned for 2 occasions. Your lordship told that it will be appear in the, as to be mentioned, but till date is not mentioned.
If we give the slip, it will appear as to be mentioned if the records are here.
I record there. I have brought the petition.
Yes.
My in urgency in this matter, there is a second appeal ready for hearing. The client is over 90 years, is not keeping well.
Which year? Second appeal?
It's 2025. The client is not keeping well, my lord. The admitted, my lord, everything is ready. LCR
Okay,
is ready.
paper books are ready.
All everything is
Okay,
ready.
to be mentioned. Yes, call the list.
My lord,
Yes.
my lord, item number 150.
Yes,
Matter was heard out earlier.
claim case.
Claim case.
So wait.
My lord,
Just wait for 2 days. If it is not taken up, I shall fix the date.
my lord.
My lord, on behalf of the petitioner, my lord, one new development has come up, my lord,
Yes.
which was I was not aware to that. Because this is a matter of 2020, my lord.
Yes.
My lord, the mat suit which was been filed, that is 35 of 2018. And in that subsequently, section 24 was filed by the wife. And we gave an objection. The mat suit 35 has been dismissed for default, my lord. That is on 7th of February 2025. So, my
this,
lord,
this,
entire
revision-
application also goes, my lord.
this revisional application has also become
Yes, my lord.
infructuous.
And even I place out 2 judgment in regard to that, my lord, where all the subsequent application also becomes infructuous, my lord.
So where is the order disposing the suit?
I'll give it to my lord. I got the copy, my lord.
Suit has been mal kindly.
Dismissed for default.
It
Kindly take, my lord. The entire order copies are there.
Malad, kindly see this.
No,
This is-
question is,
Mal-
this is the order 23 to 2026.
26. They preferred one divisional application.
Okay, this is their petition.
Their petition. They preferred
Now-
2 divisional
No,
applications.
the suit is whose suit?
Suit is their suit.
Our suit, my lord.
And
That
we
is
have
dismissed for
That
default.
is dismissed for
We
default.
have filed counter claim.
So whatever it is,
But counter
Malad-
claim is still alive.
My lord, counterclaim is different, my lord. I'm not talking about counterclaim.
no, in the counter claim, what have you prayed for?
For divorce, my lord.
For divorce.
Okay,
That is
counter-
under section
counterclaim.
23A, my lord.
And this application, this order was passed in your suit.
Yes.
What was the order passed?
3,000 rupees to be given on maintenance. That is on 5th of December 2019. At the time of Corona, my lord, we filed up this revision. But that did not appear in the list, my lord.
Now the
So-
question is, in your suit, that order was passed
Yes, my lord.
and that is dismissed. So far the counter claim is concerned, that is alive.
That is different.
That is
In
alive.
the written statement, they came out with the counterclaim.
Yes.
And that is after the application of
So
24th.
anyway, so far this matter so far this application is concerned, as it arose from the main suit, MAT 35 of 2018, okay, which was under challenge,
Yes, ma'am.
and the suit is disposed.
I'll place out a judgment of Bombay High Court. I'll place out 2 judgments, one Supreme Court and one Bombay High. Similar matter in Bombay High
But
Court.
the counter claim will continue if you are
The
agreed by,
counterclaim, I'm not saying
if
anything.
the parties are agreed by any
I'll
order.
state also, they are been appearing on counterclaim in the lower court.
Yes,
Everything goes up. Malad, kindly come to the page number my lord, 2. Paragraph number 4, my lord. The Bombay High Court. It is well settled that an order granting pending disposable of writ petition, suit and other
No,
proceedings.
page 2,
Yes,
para 2.
yes, ma'am. Para 2. Just a second. Bombay High Court, ma'am.
Yes.
Bombay High Court, para number, page number 3, my lord. Page number 3. Page number 3.
Yes.
And it starts from this section. The relevant portion I'm coming, my lord. This section specifically refers to the petition for and passing of a decree for a judicial separation. Likewise, section 2 of the Act provides for a degree of nullity of marriage. It says that any marriage solemnized after the commencement of the Act shall be null and void, and may on a petition presented either party thereto be so declared by a decree of nullity. It contravenes any one of the conditions specified in clause 1, 4 and 5 of the section 5. The section also speaks passing of the decree of nullity of marriage. Section 12 also refers to the degree of nullity of marriage on any of the grounds stated in the section. Section 13 refers to a degree of dissolution of marriage on any ground stated in subsection 1 thereof. Thus, it will be clear, now it is important, thus it will be clear that section 25(1) of the Act, which provides alimony of maintenance to a husband or a wife, as the case may be, when it uses the expression passing of any decree, only refers to passing of any of degree provided for in section 9 to 13 of the Act. Although technically speaking, dismissible or suit or a petition may be called a decree, such decree is not contemplated by section 25(1) of the Hindu Marriage Act. Accordingly, the court, in my opinion, will not have any jurisdiction to make any order for payment of alimony or maintenance in favor of husband or wife in the event of the petition for any of the degree mentioned under section 9 to 13 of the Act being dismissed. So, my lord, my suit was in regard to section 9, my lord. That is, my lord, if that was been dismissed for default.
Anyway, counterclaim remains.
Yes,
That
counterclaim
remains. I'll
remains.
place out one more judgment, that is Supreme Court
Because
judgment.
counterclaim does not go.
Counterclaim, my lord.
That
Anyway, this order was passed in your suit.
yes, ma'am. My one more judgment I'll place out.
Yes,
One
yes,
Supreme
সেটা তো
Court.
জানে।
On page number 2, my lord, para 4. It is well settled that an order granting pending disposal of writ petition, suit or other proceeding comes to an end.
Para 2.
Para 4, my lord.
Yes.
It is well settled that an order granting pending
No,
disposal of the writ.
Para 4 of the Supreme Court.
Yes, my lord. Para 4 of the Supreme Court, my
No,
lord.
no, this is High Court at Calcutta you are relying upon.
Yes, my lord.
What you have relied is High Court at Calcutta.
Oh, this is High Court at Calcutta, my lord.
Yes.
Just a second, my lord. I'll give out that one also. Yeah, my lord. Take it this one. This one. My lord, this order. Page number 2, para 4. This is State of Gujarat versus Dilip Bhai Saligram. एक मिनट पढ़े दी, suppose ये विचार. मतलब para 4. It is well settled that an order granting pending disposal of the writ petition, suit or other proceeding comes to an end with the disposal of the substantive proceeding, and that is the duty of the court in such a case to put the parties in the same position they would have been, but for the interim order of the court, any other view would result in the act or order of a court prejudicing the party for no fault of his own and would be mean rewarding writ petitioner in spite of his failure. Any such unjust consequence could be contravenced by the court. The position was highlighted in Sri Chamundi Moped Limited versus Church of South India Trust Association, CSI Synod Secretariat Madras. It was inter alia noted as follows: by considering the effect of interim order staying the operation of the order under challenge, a distinction has to be made between quashing of an order and stay of the operation of an order. Quashing of an order result in the restoration of the position as stood on the date of the passing of the order which has been quashed. The stay of operation of the order does not, however, lead to such result. It only means the order has been stayed, only not to be operative from the date of passing of the stay order. It does not mean that the said order has been wiped out for existence. So, my lord, if it has been restored, then only everything comes out as it will revive. So, in this case now, my lord, this revision is infructuous.
Yes, so let me dispose with the clarification
Yes,
that the counterclaim will remain intact.
My lord, kindly see. Yes, that will be.
That will be clarified.
Yes, my lord, that kindly see order dated 23rd February 2026, my lord, which I have referred.
Yes.
Yes. My lord, kindly see page 3. Actually, my lord, this revisional application disposed of in the year 2026. Then also, regarding my lord,
It is
CO
clarified. Petitioner shall be allowed to advance on the counterclaim and the same shall not proceed ex parte even if the suit is not restored.
Yes.
That with that he has a right to defend.
And regarding my lord maintenance, my lord, kindly see page 3.
Maintenance also goes up now.
Maintenance order, okay. If the suit goes, okay, he is not proceeding with this application as because the suit is disposed. With regard to the maintenance, you have a fresh right in a counterclaim.
Yes.
Yes.
No matter counterclaim, they did not make any application.
Whatever it is, if he,
but it is there to come out with a different thing. It's a
learned advocates for the parties are present.
And my lord, there is a suppression of fact because my lord.
This anyway,
Yes.
this revisional
Malak is a
application
suppression of fact. I don't
was
understand what
directed
reason he has set up.
against order dated
My application was section 9, conjugal of restoration rights. Restitution of conjugal rights.
order dated 5/12/2019 passed by learned additional district judge, first track, third court, Boshirat North 24 Parganas in mat suit number 35 of 2018. By virtue of the said order, the petitioner plaintiff was directed to pay maintenance of rupees 3,000 per month to the respondent opposite party. Stop. The petitioner, being aggrieved by the said order, has come up with the instant revisional application. It is submitted by the learned advocate for the petitioner that the suit instituted by his client was dismissed for default on 7/2/2025. Stop. Learned advocate further submits that in view of the dismissal of the suit dated Mat 35 of 2018, there is no scope to pass any order in this revisional application. Learned advocate relies upon the following judicial decisions. Civil appeal number 4058 of 2006. State of Gujarat versus Dilip Bhai Shaligram Pati in bracket Supreme Court of India. Next, Minarani Mujumdar versus Dasarath Mujumdar. Civil revision case number 4346 of 1960. Niche within High Court, Calcutta. Reported in MANU/WB 0078/1963. Third is Shantaram Dinkar Karnik versus Multi Shantaram Karnik in the High Court at Bombay. Reported in Manu MANU/M capital H/0016/1964. Stop. Learned advocate for the respondent submits that although the MAT suit 35 of 2018 was dismissed by the learned trial court, but the counterclaim filed by the respondent defendant in the said suit still continues, and the defendant respondent has a right to continue with the said suit. Stop. In the facts and circumstances, this revisional application CO 758 of 2020 stands dismissed as infructuous. Stop. However, the counterclaim which is pending before the learned trial court may proceed in accordance with law. Stop. It is, however, made clear that this court has not gone into the merits of the case, and parties will be entitled to take necessary steps in the counter claim without being influenced by this order.
My lord, no objection.
One more,
to
my
must
lord,
be filed.
what the order was passed by your lordship. We paid the money also.
My lord,
They later on, when the client came to me and told me this was,
Okay, I'm just doing one thing.
I have
As learned trial court is requested to
evidence is going
take
on.
necessary steps, if necessary, requested to make an endeavor if the matter can be settled through mediation and reconciliation. Stop. Before taking a final decision in the suit.
My lord, voca file be kept on
The
record.
vocalatnama file be kept with the record.
আমার নামটা আছে তো
বলছি
I am for the opposite party. I am for the petitioner in this matter. This matter has come the east of the my direct friend.
Yes, what are these applications for? You are for the petitioner.
I am for the opposite party.
Yes, you.
I am for the petitioner. What happened, my lord? This case has dismissed for default on 6th of December 2023. Kindly see the order.
No. Which is your application for restoration?
Restoration, it is pending. However, when the matter was called on 29th of July 2025, that it has passed honorable court, my lord, was that at that particular date I was not present, but
No. Which application you are moving? Can 2 of 2024?
Can 2, can 1 is it has matter has presently it has its status is dismissed for default.
Can 1?
Is filed by me, my lord, at the behest of the opposite parties in 2018 for expeditious hearing of the matter.
Anyway, but so far,
Can
Can
2
2 is concerned, it is for restoration of this CO 291. So that copy you have been served.
That, no.
My lord, since it has not served, my lord, kindly give me at another
But
date.
your lordship will see, in absence of that copy, your lordship will decide whether.
No, you serve a copy, I am making it not today.
Not today, not.
Then, my lord, this matter in the lower court was filed in 1987, and in high court it is pending since 2012. One after another dismissed for default, they are only dragging the matter.
Only one occasion it has one after not one after another dismissed.
And
But only one occasion it
Anyway,
has been
this revisional application will be heard out. What is the order under challenge?
Order under challenge, my lord, the petitioner, I mean the father of the opposite parties filed a suit for declaration and permanent injunction. The opposite party, that is the father of the petitioners of this revision application, he appeared contested for some times, but never filed any written statement. Ultimately, he decided not to appear and contest the case.
So it was decided ex parte.
It was decided ex parte.
Then he filed an application.
Order 9/30.
Yes.
That was filed, and that was misappeal before the district judge. That has been dismissed. Against that, this revision application was filed in 2012.
My lord,
So that is the main matter.
yes,
That is the main
my lord,
matter.
subject to correction of
And
my
there
learned friend. My learned friend submitted that I have never intend to
So
contest.
for
the
this application, you see, small matter, it is kept pending for so many
Indeed, my lord,
years.
what happened in the subsequently it has come up, and subsequently, my lord, during the COVID period, it is again come up. I have directed
You
to
say
some notice.
2012 matter.
And my lord, what happened? Interesting fact is, my lord.
Anyway, you serve the copy of the
Yes,
application.
but without serving the copy of application on clarification order obtained by my learned friend. But totally,
No, whatever it is, you see, you ought to have served a copy.
yes, that I can.
Yes, I'm
But
making it
little
not
bit-
today.
And my lord, what happened, my lord? I should candid because
No, you just serve. I shall hear your application.
I have served, my lord.
Thereafter, you be candid, whatever you want.
Only one point, my lord. I am
Yes.
seeking, my lord. I can application is missing, my lord. Only one. Give me one week time. Within that time, kindly fix next week. I shall.
Yes, I'm making it not today.
make it not
Okay, not this week.
not this week. Making it not this week. In the meantime, I will serve. And my lord, in next date, your lordship can.
My lord, kindly fix a date.
Kindly fix it.
Just making it not, I'm making it not this week. I shall take it up in the next week.
Yes, yes. Hey, not this one. Grateful.
সবই গেছে, ওটা না হলে ওটা কোনো এখন রেস্টোরেশন না হওয়া পর্যন্ত কোনো কিছু শোনা যাবে না।
আর আমি অর্ডারটা দেখে নিয়ে কিছু করতে পারি। Next item I'm praying for not today, my lord.
Yes, now the question is,
Your lordship, my lord, I have used an affidavit. This is the case, my lord. The claim application filed by my landed client allowed. And the father and mother was the claimant. After, during the pendency of the judgment, my lord, the mother died. So, my lord, they filed application for review. The tribunal held that they have got no power of review because that they came up before this honorable court. No order, what order was passed, that has not been annexed. Subsequently, they filed another application for review, my lord.
so you have filed an affidavit.
I have filed an affidavit. I have the railway authority has stated.
My dear lordship,
So is it an appealable? Is it an appealable order?
No, I am not on that one. The railway authority has agreed by filing the affidavit. After the death of the mother, my lord, Hindu Succession Act, my lord, class 2, my lord, the father will get the benefit. If your lordship after
No, there are any children.
Four children, they have made party, my lord.
Oh, there are
they
children.
have not been substituted. That is my lord creating.
Substituted where?
Not yet been substituted.
But I paid for.
You have filed any application?
I filed application, my lord. In the DB application, I filed.
Anyway, let this matter appear after 3 weeks.
No, my lord, next week.
No, you have not taken any steps
No,
for
my lord,
substitution.
no, my lord, everything, my lord, I have.
Advocates,
No, my lord,
the parties are
my lord,
present.
my lord, here not died. They died before the, my lord,
But you have not taken any steps.
my application was rejected by landed tribunal.
That means
Against that, my lord, this application.
Last occasion to pass comprehensive.
Oh, that
list
means
of dates. List of dates, that
no,
is not prepared.
these were the applicants before the trial court.
Yes.
Okay, so the trial court has rejected the prayer of these applicants.
My lord.
So
Against that, my lord, I have
no
prayed.
question of substitution.
No, my lord.
Whether how they are agreed, they have to justify.
Yes, that has to be.
Yes,
Let me Monday.
learned advocates for the parties are present. Let this matter appear on
Monday.
27/7/2026, next Monday.
Much obliged.
Lordship, in this matter, Miss Chandana Ghosh is appearing behalf of the petitioner minor. I am led by Miss Chandana Ghosh. I am praying for only not this week, Lordship.
Okay, not this week.
Yes.
Deeply obliged.
14 and 15, Lordship, I am for the petitioner, Lordship.
The opposite party, my lord. Mrs. Priyanka Jana is leading me in this matter, my lord. I am praying for 2 weeks accommodation.
This is a Lordship preemption matter, Lordship. Now, main question is, Lordship, regarding short deposit.
No, question is, these two matters are being heard analogously.
Analogously, because
So
Lordship,
323 is whose application?
my application, Lordship.
Okay, and this here, this
1662.
whose application?
This is my application, Lordship. Both
No,
the
no.
matter, Lordship.
This 14 is your application.
14 and 15, Lordship, in the both the matter.
Applicants are different.
Yes, one Porimal Haldar and the second matter, Lordship, it's Rajkumar Haldar.
Now, what is the ground of challenge?
Ground of challenge, Lordship, short deposit.
Okay, so
Short deposit,
let
Lordship,
it be
what-
not this week.
not this week, then Lordship, kindly direct them to file a short notes or anything because it is necessary to adjudication. Because what happened, may I submit
Is
shortly?
there any scope of any interim order?
No. Because Lordship, during pendency of this revisional application, the order has been executed. So there is no scope.
Yes,
That
record an order. Learned
kindly
advocates
fixed any date,
for
Lordship.
the parties are
2 weeks
present.
accommodation, madam.
2 weeks, Lordship. It is
On
long
the
pending matter. Before
prayer of
Haldia
the
Bench has
learned
been heard,
advocate
Lordship.
for the opposite party, the matter stands adjourned till 3/8/2026 as the last chance.
Last, grateful, Lordship. If they want to, Lordship, exchange an affidavit, Lordship, kindly direct.
No,
Because
question, it's a question of law, no question of affidavit.
because last two benches it was hard for Lordship 11 or 12 time. Now
আচ্ছা আরে রেকর্ড করে নিন তো পার্টি learned advocates are requested to come with written notes of arguments.
we have already prepared, Lordship. We have already handed over the copy
Okay.
to them.
Yes.
Defendant.
You are for the petitioner.
Defendant, appellant, petitioner.
So yes.
So, first time it is coming. But
So it is not yet admitted.
No,
The 2017 matter.
my lord.
Dagi.
It was initially dismissed for default. My lord is kind enough to restore it. Lord, kindly sees the conduct
No, what
and
is the
how
order?
the learned judge passed the order impugned. I have come only for accepting the or depositing the my lord, cost of 5,000 rupees as directed by this honorable court. I have given the explanation to that whether it can be dismissed in that fashion, and that is why my appeal is impactuous now. One page order, kindly sees. Thereafter, I am taking the facts and as well as the earlier order of this court.
Oh, what is the, you see, this is on 28/1/2016.
Yes.
Okay.
One page heard the both sides. May I read for your lordship?
Yes. 28/1/2016
My
order.
lord, if your lordship kindly take the what happened, I tell you, lordship. My lord, eviction suit decreed. My predecessor in our predecessor in interest, my lord, prepared an appeal. But in that appeal was continuing, that predecessor Bholanath Karmakar my lord expired. And we filed an application for substitution along with the section 5 application.
Okay, so earlier you see, earlier by an order,
My lord, kindly take the order.
28/1/2016,
my lord,
the application was allowed.
Yes, condoning that my lord, section 5 and directing me to deposit, hand over the 5,000 rupees to the OP. Number 2, my lord, on next page, kindly take page 18. On within time, one draft was my lord, prepared, tied to handed over to the opposite party. Number 2, they declined to accept.
Now, what is that rejection order by the trial court?
Last page. Within 2 weeks, that draft was done. My lord, kindly take. Kindly go through the one order itself. It could have been, my lord, accepted, and appeal could have been proceeded. Only on the basis of technicalities. Why technicalities? I have stated in paragraph 11. Also, court admitted that it appears that the
question
draft
is the matter was to be, the cost was to be deposited within 2 weeks.
2 weeks.
Okay, when did you deposit the cost?
My lord, on 10th. Not deposit to hand over the draft
question
to
is,
the opposite parties on 10th.
No, as per the order of this court, you were to deposit.
Kindly take the order itself.
28/1/2016.
My lord, second page.
Yes, 28.
That the petitioners are directed to pay cost of 5,000 rupees to opposite party number 2, a bank draft within 2 weeks. If 2 weeks count, it is my lord 11th. I prepared and tied to hand it over on 10th. Kindly take page 18. It is a draft dated 10th.
Yes, record an order.
And on so refused,
Learned advocate
very that date.
Petitioner
Next
is
date.
present. Hard learned
Put a
advocate
petition
for the
down.
petitioner. Peruse the petition filed. The petition is directed against order dated 20. Thirteen 8 31/8
Yes,
2016 passed by 31/8
yes
2016 passed by learned additional district judge Nodia, First Court Krishnanagar Nodia in 78 of 2008. Stop. The petitioner, being aggrieved by the said order, has come up with the revisional application. It is contended by the petitioner that
paragraph 11
that his client, upon taking steps and preparing the draft in terms of order dated 28/1/2016, purported to hand over the same to the opposite parties, but The same was refused by the opposite parties. Stop. Upon considering the order dated 28/1/2016 and the order passed by the learned trial court, this court is of the view that this revisional application should be admitted. Thus, I admit this revisional application. Let notice be issued upon the opposite parties within 1 week. An affidavit of service be filed forthwith. Let this matter appear after 4 weeks.
Let it be on 3 weeks. In the meantime, I shall complete. Well, because it is a long pending matter, I want to proceed with the matter.
I'm just keeping it 4 weeks. It will take some time. Nodia district.
Nodia, it will
Let,
go.
let this matter appear after 4 weeks. Liberty to mention.
Grateful to your lordship. 11, 12, 13, 14,
Yes.
court was closed. On 15th, I made it put up. So there is no delay on my part.
Anyway, let us see.
My lord. Grateful to your lordship. Much obliged.
17, your lordship, I appear on behalf of the opposite party number 1.
My lord, on the last occasion, my lord directed us to serve a notice. We have served. My learned friend is appearing.
The matter was admitted earlier.
Matter admitted earlier. There was a stay on the last occasion. My lord has been pleased to extend the order of stay. That stay is there till 3rd of August. Lord, this is coming from a preemption appeal, mispreemption appeal, reverse affirmation, judgment of affirmation, and we have lost in both the courts below, my lord. My lord, the issue is, my lord, the legal.
Because you are the purchaser.
I am the preemptee, my lord.
You are the preemptee. Yes, you are the co-sharer.
Yes, ma'am. Well, the issue involved here is whether preemption will lie over a Bastu land or not. That was the point raised before the learned trial court as well as the appellate court. My lord, the issue of Bastu land is pending before a larger bench, my lord. Reference is pending in CO 698 of 2018. My lord, that is the reason we did not initially move with the appeal.
So your Section 8 application was dismissed.
No, my lord, I am the preemptee. Their application allowed in both the courts below. I am coming up in second appeal, as effectively, my lord.
Revisional jurisdiction, my lord. It will be treated as a second appeal, my lord.
Okay, Section 8 application was allowed by the trial court and confirmed by the appeal court.
Yes. My lord kindly takes up page 47 of my application. This is internal page. I'm not getting. This is the learned trial court's order, my lord. That is first paragraph. That is the
yes
from the relevant judgment, my lord.
Yes.
The paragraph starts from page 46, where
Yes.
the learned trial court observed that the I'm just coming from page 46, my lord. The opposite party number 1 raised legal question that the case land is Bastu land. According to
Yes.
learned advocate on behalf of opposite party number 1, Bastu land does not come under the definition of land in the West Bengal Land Reforms Act 1955. Learned advocate cited a reported judgment and quoted therefrom in the following language. I'm placing, my lord. Having regard to the scope and object of both the acts, were of the opinion that on applying the principles of harmonious construction and with a view to remove the intrinsic inconsistencies, it should be held that the provisions of the West Bengal Land Reforms Act have no application in respect of matters covered by Urban Sealing Act. However, it is made clear that the said act will have application to the agricultural lands within the said area. Referred to 2007, Volume 3, WBLR Calcutta 93. It is further cited another judgment reported as 2012, Volume 2, CLJ Calcutta 355, wherein also Honorable High Court Calcutta followed the same principle and excluded the right of preemption over the Bastu land. Hearing argument advanced by the parties and going through the reported judgment, I think actual legal position in this regard to be discussed. Section 2, subsection 1, Land Reforms Act 1955 has no application over any land within the urban agglomeration, unless such land is situated within the restricted area as mentioned therein. On careful scrutiny of the provision as mentioned above, I find that there is very limited restriction of application of the Land Reforms Act. The land of the instant case does not fall under any of the restrictions enumerated in the Act. In reported judgments, Rajat Niyogi versus Pradeep Kumar Sen, 2010, Volume 1, CLJ Calcutta 81, and Romola Chaudhary and another versus Shuman Ghosh, 2010, CWN 731, wherein it has been very clearly and extensively discussed over the application of West Bengal Land Reforms Act in respect of the land within the urban agglomeration. In the said decision, Honorable Court declared reported judgment, 2004, Volume 2, Calcutta Law Journal, 273 is pari incuriam, as the said judgment delivered without taking note of the provision of Section 1, subsection 2 of the West Bengal Land Reforms Act. Further going through the referred reported judgments, I find that the issue is not a legal issue in the instant case, as the case property does not fall under any of the restrictions enumerated in Section 2(1) of Section West Bengal Land Reforms Act. There is no provision or interpretation of any statute to straight cut that a Bastu land is outside the scope of West Bengal Land Reforms Act and also outside the scope of preemption. This observation, my lord, this determination is pending before.
Now, considering the judicial decisions, the learned trial court came to a findings.
But my lord, presently this issue is pending before a larger bench.
So till the issue is decided, the earlier decisions will be binding upon this bench. Earlier decision of the coordinate bench, unless it is reversed by the.
Since it is pending, my lord.
No, maybe pending, but is there any interim order or something that all proceedings shall not continue?
My lord, in this matter, it is not within that reference.
Because you see,
since the issue is there,
yes.
Since the issue is there, it is my humble prayer that it should be.
It should be referred to that special bench instead of deciding.
Referred, my lord, if not referred to the larger bench, at least let the matter remain pending unless the legal issue is decided, my lord. That is my prayer, my lord.
My lord, if we
in similar
unless
cases,
you see, but unless that issue, you see, the earlier decisions are reversed, it is binding.
My lord, what in similar cases, my lord, other coordinate benches also has taken a similar view. Since
anyway, let us consider the judicial decisions, the decisions relied upon, and the matter which is pending before the special bench. Thereafter,
my lord, may I prefer one small indulgence? Yes. My lord, in this matter, I am led by Mr. Shivashish Ghosh.
Anyway, I am keeping it after 2 weeks.
My lord, I'll come.
I'll consider.
Yes, let learned advocates for the parties are present, had learned advocates. Let this matter appear for further hearing on 3/8/2026.
Well,
on the said date, the relevant decisions will be produced by the learned advocates and the decision of this special bench.
Yes, my lord, I shall. Well, the interim order may
interim order granted earlier shall continue for a period of 5 weeks or till further orders, whichever is earlier.
I'm grateful, man.
I appear on behalf of the petitioner, lordship. The last occasion, lordship, the respondent filed a affidavit in opposition where it stated that respondent number 1 and 9 had died and legal heir have to be substituted. But I give a notice to him, but he did not supply any legal heirs of the deceased respondent number, opposite party number 1 and 9. Lordship further stated that the petitioner number 2 had died. Petitioner number 2 had died. He has stated
But
Petitioner
his
number?
legal heirs has already been substituted in this application, Lordship. In respondent number, petitioner number 3.
No, petitioner number. Which petitioner died? You are for the petitioners.
I am for the petitioner.
Yes, which petitioner died?
Gulshan Bewa. Petitioner number 2, Lordship. His legal heirs Basir Khan has already next. Petitioner number 3 has already been recorded in the civil divisional application, Lordship.
Okay, petitioner number 1 is already substituted.
Substituted.
Okay. Now, petitioner number 2.
2. Gulshan Bewa.
Yes.
His legal heirs Basir Khan.
Yes.
This is the petitioner number 3.
No.
Another is, Lordship, Banu Bewa Bibi. Banu Bibi, the daughter, petitioner number 32, Lordship.
Petitioner number 32.
32. Has been substituted.
32.
32. Banu Bewa.
No, at present you are moving substitution application for which petitioner?
We need to substitute this application because of that already legal heirs has already been implemented as a party in the petitioner, Lordship. So not required to file any substitution application.
Okay, simple deletion.
Simple deletion. Kindly expunge the name of the.
Yes, where is your petition?
Lordship.
Where is your petition for the deletion of the name?
Expunging petition, kindly grant me leave, Lordship. I will file a expunging petition. Another, Lordship, Mili Bewa. This is a petitioner number 20, Lordship.
Yes.
Mili Bewa, same legal heirs have been substituted. Maslin Khan being the
No,
petitioner.
question is the petitioners which are already substituted, they are on record. Okay.
On record.
Now,
Only
those
for
who are to be
expunging
substituted for the purpose of expunging, you come with an application.
Lordship. Another thing is this, Lordship, respondent number 1 and 9. The legal heirs has not been.
So, have you filed any application?
No, Lordship, and not been affirmed, Lordship. Lordship, so I.
Respondent number 1 and 9.
1
died.
and 9. Respondent number 1 and 9.
Have you substituted them in the trial court?
No, Lordship. After filing this revisional application, they had died.
So
Respondent is stated in the
definitely in the trial court, the steps are taken to substitute them. They are the respondent defendants.
Lordship.
So definitely.
No, I am the plaintiff petitioner.
So the respondent who have died, they are the defendants.
Defendants. I give a notice to him to supply the
Question is,
legal heirs.
you ascertain from the trial court who are the legal heirs, because steps must be taken.
As your Lord.
there.
Kindly give a direction. Then.
Yes, learned advocate for the petitioner is present. Learned advocate for the petitioner is granted time to take necessary steps for the purpose of substitution of the petitioners who have died during pendency of this application, as well as with regard to the legal heirs of the deceased respondent number 1 and 9.
1 and 9. 1 and 9 not been supplied to me, Lordship.
Okay. So you ascertain from the trial court who are substituted
Lordship.
there. The matter stands adjourned till 3/8/2026, or shall I give you 3 weeks time?
3/8, Lordship. As your Lordship. Lordship, last occasion.
Okay, 10/8/2026.
Lordship. Grateful, Lordship. And kindly give me liberty to file a expunging petition, Lordship. Have not been.
Yes, I've granted you opportunity to take steps.
Lordship.
So you file that.
Lordship. Grateful, Lordship. কবে থাকবে? কবে থাকবে?
এটা হ্যাঁ এই দুটো এগুলোতে কালেকশন হচ্ছে না। দি নেম অফ দি অ্যাডভোকেট ফর পিটিশনার MS সুরঞ্জনা চ্যাটার্জি অ্যান্ড মিস্টার প্রদীপ সরকার, এটা কাট আউট। শোনো ঘটেছে কি রেসপন্ডেন্ট? Matter is put up for necessary rectification of order dated 8/7/2026. Top. In the order dated 8/7/2026, the learned advocate for the petitioner is recorded as Mr. Shonok Bhattacharjee instead of MS Suranjana Chatterjee and Mr. Pradeep Sarkar. Stop. Let necessary rectification be made and the name of Mr. Shonok Bhattacharya be recorded as learned advocate for the opposite party. Other contents of the order remain unaltered.
Lord 20, my lord, I appear for the petition, my lord. There is a can, my lord, which we have filed by the new set of advocates, my lord, for my lord, reimposition of the earlier interim order which was there. My lord, my revision, my lord, was admitted, my lord, with an interim order. Your lordship may kindly takes that interim order at page 9 of the application. Can 2. My lord, dated 20th of June 2019.
Who is appearing for the respondents?
My lord, we have served them, my lord, affidavit of service. They have not been appearing all along. I have the affidavit of service also, my lord. Lord, it will not take much time, my lord. Kindly takes.
No, question is,
yes.
What is this application for?
My lord, for my lord, reimposition of the interim order dated 20th of June 2019. This interim order, my lord, was, my lord, till disposal of the revision application. Thereafter, my lord, by mistake, I may say, my lord, the order, my lord, was made a time, was, my lord, ultimately was made time, but it was not pointed out to the court by the erstwhile advocates.
Yes, what is the first order?
My lord, 20th of June 2019 at page 9. My lord, at page 10 is the interim order which says that the opposite party and its men and agents are hereby restrained by an order of injunction from disturbing and or interfering with the peaceful possession of the petitioner in respect of the suit property till disposal of the revisional application. So, my lord, my interim order was till disposal. Thereafter, my lord, what had happened? In the meantime, my lord, this CO was dismissed for default. Thereafter, it was restored. That restoration order is at page 12. And my lord, page 14 is the order which made the order time bound. Kindly seize, my lord. Page 14, 19 June 2025. Paragraph 2, my lord. I'm sorry, paragraph 1. Learned counsel for the petitioner submits that opposite party has been duly served. Postal receipts and tracking reports have been filed.
Page 13.
Page 14.
Page 14. Yes.
Paragraph 1. However, the opposite party has chosen not to appear. In such circumstances, the interim order as granted on June 20, 2019, which was till disposal of the revisional application, is extended till 31st of July or until further orders, whichever is earlier.
Yes, record an order. Learned advocate for the petitioner is present. None appears for the opposite party in spite of service of notice. Let the affidavit of service file be kept with the record. This application is filed for necessary for reviving the interim order passed on 28th June 2019 till disposal of this application. Learned advocate for the petitioner draws attention to the order dated 20th June 2019, wherein an interim order was passed restraining the opposite party from disturbing or interfering with the peaceful possession of the petitioner in respect of the suit property till disposal of the revisional application. Stop. Thereafter, the said revisional application was dismissed on
8th of January 2014, 2024.
8/1/2024. Stop. And accordingly, the interim orders were vacated. Stop. Thereafter, by order dated 19/6/2025, this revisional application CO 1862 of 2019 was restored, and the interim order, and as per the said order, the interim order granted on 20th June 2019 was extended till 31st July 2025. Stop. As it appears that the order dated 20th June 2019 was appeared that the interim order passed on 20th June 2019 was still disposal of the revisional application. The order dated 19/6/2025 is modified to the extent, and the interim order granted earlier on 20th June 2019 is to continue till disposal of this revisional application.
Yes, can may be disposed of.
Yes. This application can 2 of 2026 stands disposed.
Your Lordship may kindly, Lord, gives me a further direction. I'll serve upon the
Yes,
respondent.
the
and-
learned advocate for the respondent opposite party, petitioner, is requested to serve once again the board of the opposite party, as well as the learned advocate appearing in the
My Lord, we
trial
do not know. They have never appeared.
no in the trial court.
In the trial court. Trial court.
Yes.
My Lord.
Opposite party as well as the learned advocate who represented the opposite party before the trial court.
I'm not kind of the divisional application anytime, my Lord, suitable.
Liberty to mention.
Very much grateful, my Lord. Ah, no.
Lordship 21, I'm for the petitioner and I'm praying for not this week in this matter, Lordship.
Yes, what is this application? You're for the petitioner.
Yes, Lordship.
Okay, not this week.
Obliged, Lordship.
Would it be my Lord's pleasure appear for some of the contesting opposite parties? Would it be my Lord's pleasure to indicate a
Okay, let it be not today, not this week. On the next week, I shall pass that order.
My Lord, 22, my Lord, I
Yes.
being the, my Lord, the plaintiff opposite parties, my Lord.
You are the plaintiff opposite party. You are plaintiff petitioner.
Plaintiff opposite parties hearing.
Okay, 22.
My Lord, yes, now defendant, my Lord, is the petitioner here. No, adjournment today. My Lord, I mentioned this matter because of, my Lord, there is a stay of the, my Lord, the hearing of the suit there, my Lord, since, my Lord, 2019. Now, my Lord, I mentioned this matter because of the fact that, my Lord, for non-disposal of a particular issue, a very limited issue, my Lord, had it been disposed of in between this, then suit has been, my Lord.
No, suit is stayed so that it does not proceed ex parte. The written statement is not accepted by the trial
He
court.
is grateful to your Lordship.
So that is why the suit will proceed ex parte.
Now, my Lord, may I tell on? My Lord, what happened? My Lord, in 2015, the suit was filed. Sometimes in January 2016, my Lord, a written statement was filed by both the, my Lord, the defendants, 1 and 2 both. Now, my Lord, what happened? In the meantime, what happened? When it, my Lord, is in the written statement, my Lord, a counter claim also, my Lord, they filed. Now, my Lord, while this was taken up, my Lord, we, my Lord, raised an objection with regard to the pecuniary jurisdiction of the court, because the counter claim, if it is accepted, then, my Lord, it would not be heard by that particular court, my Lord, my Lord, the junior division judge. Now, my Lord, that question is still there, but it has been rejected on the ground that when a written statement filed jointly by 1 and 2, both the defendant, in the meantime, against the defendant number 2, for last, my Lord, several months, my Lord, in the cost list, the matter was appearing for ex parte hearing against the defendant number 2 for not filing the written
So
statement.
defendant number 2 has come with this petition.
Both, 1 and 2 both,
Yes.
because of rejection of the written statement, as well as, my Lord, the counter claim. Because rejection of the written statement and counter claim, the order that has been recorded by the court below is that despite giving several opportunities, the defendant number 2 was not taken, or he did not take, my Lord, any step with regard to, my Lord, for setting aside of that order for ex parte hearing. He should have taken a step.
Anyway, so the matter has to be heard out. And
Thing, my Lord, another thing. Now, my Lord, the counter claim, whatever, still, because of this court, my Lord, the order passed stay with a rider that all, my Lord, whatever the application for interlocutory, that may be heard there. That interlocutory application 1 with regard to maintainability of the counter claim, my Lord, it was also, my Lord, due to be heard on 1st July, not yet heard for last several years.
so the
Since
order of rejection is under challenge in this.
order of rejection under challenge, that is, my Lord, the rejection of written statement along with counter claim.
Yes.
However, in the meantime, the court said, have your Lordship go through the order of this court. Court said that stay of the suit, but with a rider that in the meantime, there is no fetter. If the court taken up the interlocutory application. And one interlocutory application that is pending, that is, my lord, our application that whether the counter claim is maintainable at this stage or not with
No,
regard.
you see, if the trial court decides that, so what remains here? So again, that will complicate. Some again, that will be challenged. Whoever is agreed.
May I tell one thing?
Yes.
Here there is a suggestion on my.
No, another. Suppose there are certain application, addition of parties or substitution. Yes, those can be continued.
That already
But you see,
disposed of.
maintainability is a issue of law.
Malad, I have followed. Though, Malad, there is a suggestion on my part.
Anyway, I'll take it up next Monday. The entire.
My suggestion is that.
Mr. Bordon did not come today, my lord.
No, no,
He has a high fever, my lord.
I just, my lord, my suggestion before your lordship would be very good on the next day is that let them take that step with regard to that, my lord, that setting aside of that order of ex parte hearing against the defendant number 2. One application they can
Anyway,
make there.
let me hear out within 1 year.
Another
When is the next date fixed?
But the 1st July was the date. And
Now,
for the
next date?
Second date, my lord, it is not in my knowledge.
Anyway, next week, next Monday, I'll take up the matter. Yes, please come ready on the next Monday, so that the matter can be heard out.
Yes, matter can be solved, lordship. And all the matter can be delegated to the trial court to take up the matter with regard to that, my lord, even the maintainability point of that counterclaim.
So come
Lordship, kindly take
come
this
with
matter
necessary authorities, I shall decide it. Yes, record an order.
Yes.
Learned advocates for the parties are present, had learned advocates. Let this matter appear for final hearing on 27/7/2026.
Get.
Good, 27.
Under the same heading.
23, my lord, I am for the petitioner, my lord. As per my lord's direction, my lord, I have served the copy. I have
start, my lord.
What are these two applications?
One is for
restoration, another is for second
conditional
file.
delay.
Okay, whose application? Your?
Yes, my lord. I am-
Yes, what do you
Before
say?
my learned friend start, my lord,
Yes.
let them serve me the original application of the civil revision. Because my
No,
lord,
you are
what
not
has-
opposing this restoration.
What has happened, my lord, I'm telling you. Lord.
Yes.
What has happened, my lord, the title suit before the learned court below has already been dismissed for default. Now,
That has
my lord,
been challenged by
that
this
is the
application.
question, my lord, to challenge this order before this honorable court is maintainable or not.
Adjournment application was filed, but it was rejected.
Application was dismissed for default.
Yes, 913 provision is there, my lord. Let them.
So
my lord,
this is
serve
the
me-
so
let them serve me the application, my lord, main application, my lord. It will be
Let the
heard out in
restoration
minutes.
application be, my lord,
It will be
allowed
heard out
there
in minutes by your lordship.
and I shall serve
There is
the
nothing.
restoration application is served upon you.
Restoration and condonation of delay. Let them serve me.
How yes, how many days delay?
For 52 days. My lord,
So let the matter be restored, and I shall take up the main matter next Monday.
Yes, my lord.
what I am on, my lord. My lord, this civil revisional application itself is not maintainable.
Very well, you take that on the next day. Let him serve your copy.
As your
But so far the restoration is concerned, you have been served.
Very well. As your
Yes, can 2. Okay,
Yes,
can
no.
1.
Can
Yes, what
1.
was the ground for you not being present?
No,
My lord,
there is.
the learned advocate was not present, my appear due to his illness, my lord. That
Lord,
is
kindly come at page 6, paragraph 5 of their condemnation of delay.
5 and
May
6.
I read out,
Yes.
my lord? That your petitioner submits that on 24th of June 2024, when the matter was taken up for hearing, the learned advocate on record could not come to court due to his illness, since he was suffering from serious viral fever. The clerk of the learned advocate also missed the list on 24th June 2024. As a result of the honorable court has been pleased to dismiss the revisional application on the ground for default, and consequently the applications being CO number such and such are also dismissed in default, since no one appeared in the support of the instant application. 6. That the learned advocate instructed his clerk to take step for listing the matter for hearing. The clerk took the copy of the order dated 24th of June 2024 from the internet and came to know that the matter has been dismissed on 24th of June 2024. Now, my lord, kindly come at next paragraph 7. That immediately thereafter the learned advocate tried to inform the petitioner about the aforesaid facts and advising to file and recalling application immediately, but failed to do since the petitioner phone was not reachable. Till the date of filing of the restoration application, the petitioner could not able to contact with the learned advocate on record. As a result, the restoration application could not be filed within the specified time due to communication gap with the petitioner and the learned advocate on record. As such, there is a delay of 452. My lord, may I submit this, my lord? I say, my lord, well, for
more than 1 year.
non-contacting with the learned advocates over telephone, it took, my lord, more than 1 year.
When did this clerk learned
That was
advocate
not
came to
described.
know?
That was not described.
So
That
this
was
is
not
the
described.
present. Yes, record an order. Learned advocates for the parties are present. The application for restoration being Can 1 of 2025, an application for condonation of delay being Can 2 of 2025 are taken up for consideration. Heard learned advocate produce the petitions filed. Upon producing the petition, it appears that the learned advocates for the petitioner could not attend the matter when it was taken up for hearing due to his illness, and the clerk of the said advocate also missed the list. Thereafter, the learned advocate could not contact the petitioner. In the meantime, due to the problem in the mobile phone of the petitioner, upon considering the grounds furnished and considering the period of delay, this court is of the view that in the interest of justice, the delay should be condoned and the matter should be restored to its file and number. Thus, delay in filing this restoration application is condoned. Order dated 24/6/2024, passed in CO 339 of 2020 stands recalled, and CO 339 of 2020 is restored to its file and number. Let this revisional application appear on 27/7/2026. Please come ready. Okay, don't pray for any adjournment. Let a copy of the revisional application.
I am taking his mobile number.
Let a copy of the revisional application be served upon the learned advocate for the respondent who is present in court.
Very well.
So come ready, don't pray for any adjournment on that day.
Yes, ma'am. Affidavit service be kept.
Yes, affidavit of service file be kept with the record.
Grateful, man.
Yes.
Before I am for the respondent, this is a matter of 1991 preemption case.
Yes, so last 3 weeks I've adjourned the matter.
My lord,
Times, my lord.
my lord, kindly be taken up next Monday final without any adjournment, my lord. I have got the wrong brief actually, my lord.
You are led by your senior.
Yes,
Your senior argued the matter.
yes, my lord.
So what is to be done? Only written notes of arguments.
They have already filed their written notes of argument. Subsequently, they file another application. They try to delay the matter. That
No,
is the
my
whole-
lord, not
Anyways,
my lord.
Learned advocates for the parties are present. Let this matter appear on 27/7/2026.
my lord, they prayed for time. My lord, let it be gone down. my lord.
আচ্ছা আচ্ছা learned advocate আচ্ছা ওটাকে ইয়ে করে দিন তো as prayed for by learned advocate for the petitioner, let this matter stand adjourned till 27/7/2026.
Would it be lawsuit to point out this for last chance?
Anyway, it is
Because it will
expected
take several times.
on the next day you will not
Next
pray.
date, my lord, matter will be.
Yes.
My lord, this is the appeal of insurance company. Lord, I have come up mainly on the ground of quantum.
Yes, which page?
My lord,
Let
your
us
lordship
see
is
which-
referring to the award passed by the learned tribunal, my lord. That is at page number 12 of my lord's paper book. Lord, additionally, Lord, I have also taken, Lord, two other grounds, but those are not, Lord, very conducive in the sense that I have not been able, Lord, to satisfy the learned tribunal judge, even myself, Lord. Lord, your Lordship will kindly, Lord, the award is at page number 12 of my Lord's paper book.
Yes, yes.
Lord, I'll just give the gist so that it is easier for your Lordship to understand, Lord. In that context, your Lordship will read the judgment. Lord, a minor boy, 14, 15-year-old boy, Lord, he died in an accident. Lord, on the basis of, Lord, the Minimum Wages Act, Lord, monthly income of rupees 10,775 per month was considered for assessment. A principal award of rupees 17,50,100 was passed. Lord, I have secured the awarded sum with my Lord's court, Lord, along with the interest.
Yes.
Lord, I'll just, Lord, invite first of all, to your Lordship. Lord, I have since, Lord, my major ground is on the quantum. Lord, though, Lord, I have also taken the plea of involvement of the vehicle because of the delayed lodging of FIR by nearly 20 days after the date of accident. And thirdly, my Lord, I have also taken a plea my Lord, the third plea, my Lord, of insurance company that the motorcycle in which, my Lord, the deceased boy was going as a pillion rider was being driven by a person, my Lord, who was holding a learner's license. My Lord, one is quantum, two is delayed lodging of FIR, which results in non-involvement, and three is, my Lord, the driving license. The person who was holding a learner's driving license cannot carry a pillion rider. My Lord, point number 2 and 3 at the outset, my Lord, I must clarify, my Lord, those have not been argued merely. So I would not be succeeding in those. My Lord, as far as the delayed FIR is concerned, charge sheet is there against me, eyewitness is there against me. So, my Lord, delayed FIR point, my Lord, I would not be, my Lord, succeeding before your Lordship with regard to the involvement. And third point, my Lord, which I had indicated to my Lord, that was with regard to the driving license. That also, my Lord, was not argued before the court below. So I come back, though I have taken, my Lord, your Lordship will kindly, my Lord, refer to my argument that I have raised these issues. But in order to, my Lord, shorten the time of your Lordship, my Lord, and save my Lord's trouble, Lord, I would be emphasizing mainly on the point number 1, that is the quantum. Lord, as I stated, my Lord, the deceased, my Lord, was a minor boy between 14 and 15 years old. He was a student of class 10. For assessing his income, my Lord, a monthly income of rupees 10,775 on the basis of Minimum Wages Act was taken into consideration. Lord, I'll just invite your Lordship, my Lord, to the relevant part. My Lord, the award starts at page 12. My Lord, will kindly come to page number 23. There's an internal page of internal page 12 of the award passed by the tribunal, running page 23 of the paper book.
Yes.
Income of the deceased, my Lord, at the bottom, your Lordship will kindly see. Is my Lord there, my Lord?
Yes, yes, yes.
As per the claimant's application, deceased was age of 15 years. He was a brilliant student, studying in class 10 and had bright prospect of earning good income in future. They have set out rupees 15,000 per month as the prospective income of the deceased victim. Claimants have tendered progress report card of the deceased victim issued by Jongipada BC Kundu Memorial HS School showing his class 8 annual examination result. The same has been marked as Exhibit 14. Headmaster of the above named school has issued a certificate on 7th May 24. My Lord, the accident, my Lord, was on 29th April 21. So, my Lord, 7th May 24, Exhibit 15, certifying that the deceased victim was studying in class 10 on 29 September 21. That is the date of accident, my Lord, when he met with the fateful accident and lost his life. Para 31, learned advocate for the claimant placed his argument stating that the victim was a bright student of class 10 and of the age group of 15 years. As such, there can be no point in insisting for proof of evidence of his income. rather than notional income as per the applicable rate under Workmen Compensation Act, which is applicable to skilled workmen, should be considered in fixing the notional income. Learned advocate for the insurance company assailed the argument, stating that there being no proof of involvement of the victim in any avocation at any point of time, the theory of notional income does not apply. 32. Invariably, the deceased victim was a student studying in class 10 when he met with the accident. He was never into any avocation for earning. In such backdrop of the matter, wisdom can be borrowed from the observation of the Honorable Apex Court in the case of so and so, wherein it was held that the compensation, therefore, is to be assessed on the basis of said minimum wages on the assumption that the appellant would have been able to earn after attaining majority. Applying the aforesaid judgment, above mentioned judgment, in the context and view of the circular number so and so, the employees the minimum monthly rate of wages for the skilled employee in the state of West Bengal for the period 1st July 21 to 31st December 21 was rupees 10,775. Accordingly, the deceased victim is thus assessed to have an income of 129,300. This is the basis, my lord. 10,775 was
Now,
taken.
let us see this decision which was relied upon by the trial court.
My lord, that decision, my lord, this Ayush, that says monthly wages to be considered.
No. In case of minor.
Yes, in case of minor.
Let us see the decision.
This is the decision.
Ayush, judgment Joseph.
My lord, kindly see para.
Yes, anything else?
My lord, this is it. My lord, I assail, my lord, and I join issues.
Ayush, yes. Yes.
My lord, this quantum, my lord, I am challenging, my lord, on two parts. One is, my lord, this monthly income. And secondly, my lord, the consortium was granted to both, since the deceased was the minor, my lord, both parents were the claimants, mother and father. Consortium was granted to them, my lord, they are not entitled to. That 88,000, my lord, I am also, my lord, challenging that.
No, consortium is granted to parents in all cases. Parental consortium, that is, had it been spouse and parents, other than parents and spouse, yes.
Lordship. My lord, these are the two grounds. Now, my lord, as far as consideration of this circulars is concerned on the basis of his 10,775.
No, let us see how far this judgment can be applied to this case.
Lordship, my lord, that's what I am coming to. My lord, this circular, my lord, for my lord's convenience, I am handing it over, which was relied upon by the learned trial judge, my lord. This is the circular referred to. Your lordship will kindly see the box, my lord. First column, second column, skilled, 10,775. Monthly minimum rates of wages. Daily 414.
10,775 for skilled.
Skilled work. Yes, my lord, this was made applicable in our case. My lord, now, my lord, admittedly, in this case, deceased was a child. My lord, between the age of 14 years, some months. 14 to 15 years. My lord, your lordship will kindly come to page number 1 of this paper book. Where the pleadings are there, my lord.
Yes.
My lord, column number 3, age 15 years.
Yes.
4, student.
Yes.
5, name and address of employer not applicable. 6, monthly income, my lord. Prospective income 15,000 rupees per month. That's what they say. So this is prospective. Then, my lord, your lordship will kindly come to page number 3, my lord.
Page number 3, yes.
Column number 22.
Yes.
The compensation claim 12 lakhs. taking prospective income of 15,000 into consideration, this 12 lakhs has been claimed.
It is their claim.
It is their claim. Yes, it is their application, my lord.
Yes.
And then, my lord, your lordship will kindly come to page number 39, wherein, my lord, the father of the boy has given evidence.
Yes.
Page 39 of my lord's paper book.
Yes.
My lord, paragraph 3. That my son was a brilliant student of so-and-so school. At the time of accident, my son was aged about 15 years. At the time of accident, my son was the student of class 10 of Jongipara school. And then, my lord, paragraph 4, that due to accidental death of my son, was the only child in my family. My family has been suffered for mental shock agony, and I pray for compensation of 12 lakhs. Lord, in pleading, in evidence, they have paid for 12 lakhs. My lord, I am aware of the fact, my lord, the court, in order to come to the just compensation, my lord, can, my lord, either increase the compensation amount what has been claimed, or, my lord, it can also decrease. My lord, the point is that the just compensation has to be assessed. This is what, my lord, our endeavor is.
Pleadings and as well as evidence, 12 lakh is claimed.
Yes, 12 lakh has been claimed. My lord, award is, my lord, as I stated earlier, my lord, 17 lakh 50,180 principal sum.
And it was claimed 15 lakh.
12 lakhs.
12 lakh.
My lord, now this assessment has been made on the basis of this circular. My lord, when we, my lord, assess the compensation, my lord, in each and every case, my lord is coming first of all to the point for assessing the income of the victim, my lord. On the date of death, my lord, what was the income? In every case, first of all, my lord, your lordship asks us what was the income and how this income is, my lord, derived at on the date of accident. This is, my lord, this is indisputable. I need not show any judgment
This
to my
is
lord.
2021.
This is 2021.
An incident took place?
My lord, incident in 2021 only.
21.
Lordship. My lord, on the date of death, in this case, there was no income. This is an admitted case. Some notional income has to be considered or generated, my lord. Earlier, my lord, 2, 3, 4 years back, my lord, the maximum income, my lord, which was considered for the case death of a minor was, my lord, initially it was 15,000 rupees per annum, and then thereafter it was increased to 3,000 rupees per month, that is 36,000 rupees per annum maximum. In most of the cases, my lord, it was shuffling between 25,000 per annum to 30,000 rupees per annum. This was, my lord, the rough, my lord, the boundary within which the income of the minor, my lord, was used to be considered. Now, my lord, for the last 2-3 years, this Minimum Wages Act, my lord, Honorable Supreme Court, it has gone into the mind of Honorable Supreme Court. Their lordships in their wisdom saying that, no, forget about this 25,000 rupees per annum, 30,000 rupees per annum. We will take it over and above 1 lakh by virtue of these, my lord, Minimum Wages Act. My lord, I put this question to myself. When, my lord, admittedly, on the date of accident, my lord, deceased was not earning any money. Not only that, my lord, I go a step further. My lord, deceased was 14 or 15-year-old, anything in between those. My lord, he would have earned
Class 10 student.
Class 10 student, my lord. Age is 15, they say, my lord, it was 14 years some month. That is indisputable, my lord. My lord, what I say, this prospective income, what they claim, my lord, he would have earned after 7 or 8 years, at least, my lord, not before the attaining the age of 21. Otherwise, my lord, this Child Labor Act would come into, my lord, problem.
After 18 years.
18 years, my lord. Still, my lord, after 3 or 4 years, taking the best case of the claimant. My lord, in 3 or 4 years, there would have been, my lord, a number of eventualities. He would have survived. Otherwise, he might not have survived. Keeping those aside.
Could have become a doctor also.
He could have become a doctor also. Yes, yes. But, my lord, by looking at the background, my lord, he could have become a doctor. My lord, I do not doubt, my lord, that he could not have. But your lordship will kindly, my lord, consider the background of this boy.
So what was his academic result was considered?
My lord, he was a student of class 10. The
class 8 result was considered.
Class 10, yes, class 8 result was considered.
He was about to appear in the final examination.
He was about to appear in the final examination. But before that, my lord, I'll also then, since my lord had asked this question, that I'll also show, my lord, page number. My lord, page 39.
So the learned trial judge considered minimum wages to
Milord,
be
your lordship will kindly come to page 41.
41. Yes.
Milord, the occupation of the father at page 39, Milord. I failed to, Milord, invite your lordship. No, kindly come, Milord. Examination in chief of the father, page 39. Debobroto Guchait is my lord there, Milord.
Yes.
By occupation, cultivation. Residing at so and so, Milord. Village and post office, Jangalpara. Milord, this background check your lordship will also have to see. Milord, on presumption, Milord, we are assuming things. That yes, this could have been, this could not have been. But Milord, the
Because
fact
he was
is,
a class 10 student, not
Yes.
that after passing class 12 or 10, he used to work in a shop or a labor.
no.
This is not the
This
issue.
is not. But
He was a student.
He was a student, Milord, and the father was a cultivator.
Yes, father may be a cultivator.
Milord.
He was a student of this particular school.
Yes, Milord. Milord, the certificate, Milord, is at page number. Last annexure, Milord. Page 76. 76 or 75. This is a certificate of class 8.
76.
75, Milord.
Page 75. Yes.
This is the class 8, Milord, mark sheet. Milord, anything between 60 to 65% is there. I don't dispute that. Class 8 mark sheet, Milord, 60 to 65% is there. Milord, be that as it may, Milord, I was, Milord, joining issues on the point. Milord, on the date of accident, Milord, there was no income. This prospective income, Milord, has been shown that he would have earned this much amount of money, Milord, after a few years. So, Milord, what I pray before your lordship, Milord, I do not say your lordship will not follow this, Milord, minimum wages act, since lately Supreme Court is giving this. But your lordship will kindly, Milord, in order to arrive at just compensation, Milord, this advantage of, Milord, this 4, 5 or 6 years which has been given to the victim, your lordship, Milord, kindly adjust that. Because, Milord, this income, if there be any, Milord, I put in this clause, Milord, he would not have earned before 5 or 6 or 7 years, if at all. So, Milord, your lordship will kindly, Milord, either reduce this Milord monthly income part or reduce this multiplier part, either of the two. This is first part, Milord. Secondly, this income.
Yes, with regard to bachelors, multiplier, which multipliers are applied?
Milord, corresponding to the age.
Same.
Where
parents, applicants' age or the victims?
Multiplier is always made applicable corresponding to the age of the deceased.
It's not that in case of bachelor, the
No,
victim's
Milord,
age.
only the deduction for personal
That is 50%.
I'm grateful to your lordship. Absolutely correct, Milord. Milord, now second part, Milord, your lordship will kindly, Milord, take that part into, Milord, consideration that this 4, 5 or 6 or 7, whatever years, Milord, this advantage has been given, Milord, while Milord, considering the income which he would have earned after 6, 7 years, the income on the date of accident is not being considered. It's a huge advantage given to the claimants, Milord. Milord, I'll put it, Milord, I'll give, Milord, by one illustration, if lordship, Milord, is kindly consider. Milord, today I am working in a concern. Next year I would retire. I earn, Milord, 10,000 rupees per month. After 1 year, Milord, I would not be earning anything. My prospective income after 1 year would be 0. But since I die today, assessment is being made on the basis of my today's income, not my income after 1 year or maybe after 1 day. If I died, Milord, if...
Had he been a major, worked as a labor or whatever it is,
Milord,
had he been a major,
yes,
then you see the income, if income not proved, notional income,
yes,
if occupation proved,
lordship,
minimum wages act,
lordship.
But the question is, he is not a major and he was a student. and this prospective income.
Yes, my lord, this prospective income, my lord, since I was, my lord, submitting on the point of, my lord, income on the date of accident is always considered. My lord, the illustration what I gave, my lord, today, my lord, your lordship will kindly pardon me for repeating, my lord. My lord, today I am working, my lord, in a concern, my lord, at the rate of, my lord, 10,000 rupees per month. My lord, tomorrow is my retiring day. After tomorrow, I will not earn even 1 rupee after my retirement. I die today. My today's income is taken into consideration 10,000 rupees per month for assessing, my lord, this loss of dependency for my widow, for my children. In this case, my prospective income after 1 day will not be considered. After 1 day, I am zero. After my retirement. Supreme Court says, no, your income on the date of accident would be considered. And I or my heirs get all the advantages of rupees 10,000. From tomorrow, I will not be earning anything. Forget about that. Today, because today is the date of accident. In this case, the date of accident is forgotten. My lord, why, my lord, I am being deprived, my lord. This is law of equity. In one case, you say date of accident is to be considered. And in another case, you say, no, I will consider 5 years from the date of accident. You give that, but at least law of equity, my lord, says that you at least reduce some quantum also.
So that prospective will not be taken into consideration.
Lord, I say you take into consideration, but reduce some, give some.
So the learned trial judge considered how much? 12,000?
10,775, my lord, as per the circular.
10,000?
775 per month. In view of the circular, my lord, I have shown to your lordship the circular. That is what, my lord, the skilled worker, my lord, says. Lord, I join issues here. In one case, you say, I will consider date of accident because you want to give maximum advantage to the claimant. You give it. I bow down to your lordship, my lord, that date of accident is to be considered. But in the next case, when I say your lordship will kindly consider date of accident, then the Honorable Supreme Court says, no, forget about that. I will not consider the date of accident. I will consider what he would be earning 5 years or 10 years after the date of accident. This is what my problem is today. So I say you consider after 5 years or 10 years or maybe 15 years, this child would have been 3 years old. Had he been 3 years old, again you would have gone back to the Minimum Wages Act.
So apart from this, Master Ayush, any other decisions?
My lord, there are 2-3 other judgments also, my lord.
That 5 lakh, there was the uniformly it was made 5 lakh earlier.
No, my lord, earlier it was 1,54,500.
So 5 lakh is also there.
My lord, 5 lakh, my lord, is in the case Supreme Court is saying in one of its last judgment, when anybody without proving rash and negligent driving, my lord, is getting, even in case of minor, if it is under 163 capital A, is earning 5 lakh, then why not give that advantage of 5 lakh in 166 also? In
minor,
case,
in case of minor.
Yes, in case of minor. Yes, in case of minor, my lord. Or for that matter, anybody. My lord, suppose, my lord, a person earns, my lord, 4,000 rupees. His assessment comes to 4,58,000. He files a case under 163 capital A. Supreme Court in one of the judgments says, when a 163 capital A, now it does not go into the computation part. It is giving a flat 5 lakhs. So in 166 also, let us not reduce the quantum from 5 lakh. Let us give at least 5 lakhs of rupees. Minor, major, whatever, my lord. So here, my lord, here the case is different. Here Supreme Court says it is 166. Here Supreme Court says, my lord, we will consider prospective income, what he would have earned after 5 years or 4 years or 6 years after the accident. Taking that prospective income into consideration, we will make the calculation today. My lord, this is where, my lord, I join issue. This is where
this future prospect.
My lord, future prospect has also been given. We do not know, my lord, what he would have earned, what he would not have. My lord, taking this 10,775 per month, my lord, future prospect has been granted. So, my lord, monthly income, in other words, my lord, is coming to approximately 16,000 or something like that. My lord, 15 to 16,000.
No, monthly income, yes.
Because, my lord, 10,775 plus 40%, that has been granted. My lord, what I plead before your lordship today, my lord.
So it is in Zone A.
My lord, no, it is not in Zone A, my lord, because I read out the address. Your lordship will kindly see the address, my lord, in the claim application. Clause number 2, page number 1. Is my lord there, my lord?
No, just I'm going through.
Lordship. Paper just like dawa ache, page number 1 clause 2 minute.
Page 1.
Page 1 clause 2 minute, the address. Minute clause 2 is my lord there.
Yes.
Village and post office, minute Jongipara.
Yes.
Police Pursura, district Hooghly. Minute it would be in zone B.
Zone B, Hooghly district.
Lordship. Minute it would be in zone B as per minute my knowledge goes. Then my lordship, minute the maximum compensation what they have prayed for in their pleadings as well as in evidence.
It's 12 lakhs.
It's 12 lakhs. My lord, I again, my lord, repeat.
And the awarded is
17 lakh 50,180.
Okay, just let
My lord, I know, my lord, because my learned friend would counter me that, my lord, whatever is claimed, my lord has ample powers either to go beyond that or to decrease that. My lord has, but my lord, taking note of everything, taking note of the submissions what I made before your lordship, and my lord, taking note of this notification, my lord, where he has been considered to be a skilled worker in zone A, my lord, it would reduce in any event, my lord. And since they asked for the maximum sum of 12 lakhs of rupees, my lord, I would not say, my lord, your lordship will kindly bring it down to 5 lakhs or something, but at least, my lord, you should not go beyond the 12 lakhs, taking, my lord, just compensation into account, taking into account that this victim would have earned this money, if at all, had he survived by other means also after 5 or 6 or 7 years. This advantage, my lord, is not to be given, my lord, because your lordship, my lord, in the law of equity, your lordship will keep both parties at similar footing, my lord. My lord, these are my submissions, my lord.
Yes, just a minute.
Lordship.
Yes.
My lord, kindly see what my learned friend submitted, page 41. What he said, that is hypothetical. What is the evidence? What is the four corners of evidence? My lord will see that nowhere insurance company put any question regarding income. Say page 41, PW1. Regarding income, no question was put to the witness, no denial, nothing. There is no specific denial in the evidence. So it will automatically substantive evidence, which will go in my favor. No denial, nothing. This is very, very important in this case. Insurance company did not deny the income of the deceased. So unchallenged substantive piece of evidence before your lordships. First point. Second point regarding age also no question was put regarding age. Page 41, my lord. Kindly see. Cross-examination open number 2 is very, very important. Very, very important. For the first time raised this point regarding income. Then regarding WS, there is also no specific denial. General denial, opposite party page, my lord, kindly see page 5 of WS. Page 5. Para 4 of WS, written statement filed by the insurance company. Page 5. 1, 2, 3, 4, 5, recital of the opposite party particularly denies the about a student denied, age denied, and the income denied. Nothing more. No specific denial. This is not the income. Challenge the income, nothing. Now the question is, if that be so, then this is also decision of the Honorable Supreme Court, where
which
age
case?
of the victim 16 years. The another decision of the Honorable.
Yes.
Where the apex court took income of the deceased 10,000 per month. 16 years old, my 15 years old. That means the notional income assessed by the tribunal was accepted. Tribunal took notional income 10,000 and Supreme Court also accepted that. Added 40% future in less 50% reduction personal expenses.
এর কোনো নাম আছে জজমেন্টের? হ্যাঁ,
নাম আছে ওই কি?
নাম আছে?
শ্রীমতী বি নাগা।
শ্রীমতী বি নাগা। শ্রীমতী বি নাগামণি। হ্যাঁ।
This is the decision of the 2026. Here Supreme Court, here also Supreme Court, the decision also only child. My case also only child. Para 6 last para 6 last line. The deceased were the only child of their parents in both the appeals. My case also only child. সবের নীলমণি একটি ওই হচ্ছে ছেলে। আমার কেসও একই স্যার, সেম। Here also Supreme Court took 10,000 per month. And notional income, my lord, the another decision which I filed before your lordship, kindly see the page. দেখছি ওটা নিয়ে হাতে ধরে নেন না। হ্যাঁ বলবো। Volvo. My lord, kindly see para 7 of the previous judgment. 22 to TSC 360.
Para 7.
Para 7, my. My lord, the another decision which I have.
Yes.
High Court has assessed the aforesaid notional income 50,000, but which was not found to be justified. It was observed that the girl would be entitled again 5 years aged girl. In this case, age of the girl was 5 years old only. Justified by this court. It was observed that the girl would be entitled to minimum wages payable to a skilled workman. The appellant was in the state of Haryana, etc. Haryana skill is 3,708. Para, my lord, kindly see para 8. Hence, as per the above, the minimum wages payable to a skilled workman, 2011, 3,000 plus, that's what is taken. In my view, the minimum wages on the date of accident is rounded up. The compensation is therefore to assessed on the basis of said minimum wages. On the assumption the appellant would have been able to earn after attaining majority. Thus, para 13, come to the para 10 then. 3,700 plus 40%, 5,180. Then thereafter, reduction thereafter, multiply. This is the decision, another decision of the Honorable Supreme Court, where Supreme Court had given the 10,000, more than 10,000. Regarding to delay in affair, but only son had died 20 days, nothing. They lost everything, mentally perplexed, perturbed. I'm sorry to say this point should not be hesitated.
Now, in this present case, where this 51,720 is with regard to what? Future prospect?
51,000?
720?
Yes, future prospect.
ঠিক আছে, ছিলেন বাদ যাবে।
Yes, anything else? What? Anything?
No. Milord, one line rejoinder, Milord, one line. Milord, my learned friend is not surprisingly emphasizing that in written statement I have not disputed. Milord, what am I going to dispute? He was a student, he was not earning, that's what they say. Why shall I dispute that? This is very strange, Milord, statement being made before your lordship that I'm not disputing. Why am I going to dispute the age? Why am I going to dispute the income when he was a non-earning person, Milord? It's a strange argument is being placed before your lordship. Milord, as far as the Ayush is concerned, Milord, the judgment, Milord, that Milord related to Milord a very minor child, Milord, who became paraplegic from the waist below. Milord, from waist downwards, Milord, he could not move at all. So, Milord, I have every reason, Milord, that Honorable Court should be more sympathetic to that person. And Milord, secondly, Milord, as far as the Nagmani is concerned, Milord, Nagmani, Honorable Supreme Court held that whatever, Milord, tribunal had considered, Milord, the wages or the monthly income, 10,000 it was considered. Insurance company did not prefer any appeal against that. And that is why Supreme Court said that since you did not prefer any appeal, you have accepted that. So in Supreme Court, ultimately, Milord, held that 10,000 held by the tribunal, Milord, to be correct. On the basis that insurance company had not preferred any appeal.
Here,
Milord,
insurance
this
company did not challenge the income.
again,
Again,
ridiculous argument.
That's what I am telling.
I'm not
Yes,
challenging the income.
Now the question
He was not
is,
earning
You
anything.
did not challenge the income.
instead of instead of
No
skilled
evidence.
worker, is there any bar to consider this person as a semi-skilled worker? That is the question.
No, Milord,
Instead
there
of-
cannot be any bar. Milord, this is the assumption.
No. Instead of skilled worker, it can be considered as semi-skilled worker. And
Semi-skilled,
consider-
Milord, on unskilled, Milord, because these are assumptions. Milord.
Consider the income accordingly.
Milord, these are assumptions. And zone is B, Milord. Milord, I'm sorry, Milord. Milord, in 2021, Milord, when this accident had happened, Milord, the maximum compensation, Milord, in those days, in 21, Milord, as per the Supreme Court, Milord, was hardly crossing 5 lakhs. It is now, Milord, in 26, it has gone, Milord, by the subsequent judgment of 25-26. It is going, Milord,
No, the
by leaps and
26, you see, 26, the accident was related to which year?
21.
21. And 2022 accident?
Milord, these were decided subsequently. This is what I say. Milord. Earlier, Supreme Court, Milord, also confining, Milord, this Kurban and Sari and these other judgments, Milord, they were confined to less than 5 lakhs of rupees.
Yes. Actually, earlier it was.
So, Milord, the way the days
there
are.
was 5 lakh also.
Yes, 5 lakhs also, Milord. This is what I say. When this claim case was filed, Milord, the claimants had never thought they would get more than 5 lakhs. Now, in 2026, Milord, the cases are pending, so they are thinking, Milord, that let us increase. Let us take the advantage of the subsequent judgments.
Inflation and other factors.
Inflation, Milord. Your Lordship will kindly add inflation to 5 lakhs and grant them. Your Lordship will accept this argument. They are saying inflation. Your Lordship will add inflation on 5 lakhs and then grant them the compensation. I don't argue, Milord. I give up my case.
What you can go beyond evidence.
My Lord will accept their evidence. Milord, this is the 4th time he is saying evidence. We'll accept the evidence, give the inflation advantage, and Milord conclude the Milord calculation part.
Yes, take down. Huh? Okay. একটা জাজমেন্ট আছে ওটার একটা অ্যাপিল একটা জাজমেন্ট রাখা হয়েছে আর একটা রাখা হয়নি এফএম এ না তাহলে তো দুটো অ্যানালগাসলি শোনা হয়েছিল ওই এফএম এ দুটো রাখা হয় Advocates for the parties at present are learned advocates. The appellant before this court was an opposite party in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 16/11/2024 passed by learned additional district judge 5th Fast Track Court Alipur South 24 Parganas. The case of the claimants before the learned trial court may be summed up thus. On 29/6/2021, at about 15:15 hours, while the victim was on one TVS APACHE motorcycle bearing number WB-18 capital Z stroke 6723 within bracket hereinafter referred to as the offending vehicle as its pillion rider while coming from Jongolpara side to Arambagh when reached a place near Jangapara, Kodumtala, crossing the rider of the said motorcycle drove it in a rash and negligent manner and thereby lost control, causing the victim to fall down on the roadside, sustaining serious injuries on his person. Stop. He was shifted to Sirampur Rural Hospital, where the doctors declared him to have brought dead. Pursuant to filing of the case, notice was issued upon the opposite party vehicle owner and the opposite party insurance company. Opposite party vehicle owner entered affiance and filed written statement, but thereafter did not contest the case. Stop. The opposite party, United India Insurance Company Limited, contested the case by filing written statement. Issues were framed and evidence was adduced. Stop. The learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates for the parties, was pleased to dispose of the claim case by observing and directing as follows. Page 30. 30-31. Hold it. The opposite party, the appellant, United India Insurance Company Limited, being aggrieved by the judgment and award passed by the learned trial court, has come up with the instant appeal. Stop. Heard learned advocate for the appellant and learned advocate for the respondent's claimants. Peruse the evidence adduced and materials on record. Learned advocate for the appellant submits that the case of the claimants is doubtful as the FIR was lodged after 20 days. Stop. Learned advocate further submits that there is that the owner of the vehicle permitted the vehicle to be driven by a person who was holding learner's license. Thus, the insurance company be absolved of the said liability. Stop. With regard to the quantum of compensation awarded, learned advocate submits that it is an admitted position that the victim was a student of class 10 and was not earning anything, and the income which the claimants contended is the prospective income. Stop. It is submitted by the learned advocate that the compensation awarded is excessive and the same should be reduced. Learned advocate for the respondent's claimant submits that no cross-examination was put with regard to the income of the victim and the occupation. Thus, at this stage, it is not open to the insurance company to raise the plea. Learned advocate relies upon the two judicial decisions, namely Master Ayush versus branch manager, Reliance General Insurance Company Limited and another, reported in 2022 within bracket 2, T capital A capital C 368 within bracket Supreme Court. Next is Srimati B. Nagamani and another versus M. Nirai Pandi and another, reported in 2026 within bracket 2, TAC 392 within bracket SC. Stop. With regard to the submission of the learned advocate for the appellant that the FIR was lodged after 20 days, it is well settled by different judicial decisions that mere delay in lodging the FIR is not fatal. Stop. In Indian societies, family members after accident rushes to hospital and not to police station. Stop. In the instant case, the claimants who have lost their child in a road accident cannot be expected to go to the police station within a short period. Thus, the delay in the instant case is not fatal. Stop. With regard to the submission of the learned advocate that the vehicle owner permitted the vehicle to be driven by a person who was holding learner's license, such plea cannot be taken as this stage, as no evidence was adduced in this regard before the learned trial court. Stop. Now, with regard to the quantum of compensation awarded by the learned trial judge, this court is of the view that in a compensation case filed by parents of a deceased child, the compensation which is awarded to the parents who have lost their child in street accident is not a bonanza, but simply a monetary consolation. Stop. Parents with heavy heart come before the court for monetary claims, and unless there is perversity in the order passed by the tribunals or courts, it would not be reasonable, passed by the tribunals, courts should be slow in interfering with the compensation awarded in such type of cases. Stop. Upon considering the decisions relied upon by the learned advocate and the decisions relied upon by the learned trial judge, this court does not find any error with the decision of the learned trial court in proceeding to decide the compensation on the basis of Minimum Wages Act. Stop. However, considering the fact that the victim was under Zone B, and it is always not necessary that a minor child has to be treated as a skilled worker. He may be a semi-skilled worker also. It would be just and reasonable to consider the minimum wages of both semi-skilled and skilled worker of Zone B and proceed on the notional income of rupees 9,000. Stop. In the event the notional income is considered to be rupees 9,000 per month, 40% added, the total monthly income comes to rupees 12,600. The annual income comes to rupees 9,000. The monthly income comes to rupees 9,000. 40% future prospect added, which is 3,600. The total monthly income comes to rupees 12,600. The annual income comes to rupees 1,51,200. Stop. 50% deducted on account of personal expenses brings the annual dependency loss as rupees 75,600. The multiplier of 18 being applied, the total dependency loss comes to rupees 13,60,800. Further, the claimants respondents are entitled to compensation of rupees 30,000 on account of loss of estate and loss of consortium, and rupees 88,000, 30,000 on loss of estate and funeral expenses, on account of loss of estate and funeral expenses, and rupees 88,000 on account of loss of consortium. Stop. Thus total compensation comes to rupees 14,78,800 by arithmetical calculation. Stop. However, this court is of the view that compensation of rupees 15 lakh is just and reasonable. Next. Hence, this appeal FMA 1196 of 2025 stands disposed. The judgment and award dated 25th day of March 2024 passed by learned Additional District Judge, 5th First Track Court, Alipur, South 24 Parganas, in MSC case number 1182 of 2021 stands modified to the extent that the claimants respondents are entitled to rupees 15 lakh from the appellant insurance company, along with interest at the rate of 6% per annum from date of filing of claim case till today. The appellant insurance company shall deposit rupees 15 lakh along with interest at the rate of 6% before Registrar General High Court, Calcutta, within 8 weeks from the date of communication of this order. In the event the compensation awarded by the learned trial court is already deposited, no further deposit be made. The claimant's respondents will be entitled to withdraw the compensation upon compliance of necessary formalities. Stop. The balance amount, if any, along with accrued interest, we return to the appellant insurance company. Stop.
Extremely grateful to my lord. I am obliged, Your Lordship.
This appeal, along with all interlocutory applications, stands disposed.
I'm appearing. My lord, I am for the appellant in this case.
Yes.
My first submission would be, my lord, in this case, insurance company denied the insurance policy covering the date of accident.
Yes.
Now, kindly see page এটা কোথায়? এই যে page 56, my lord. No. My lord, got it, 56.
Yes,
This is the copy of the insurance policy,
yes.
which was filed on behalf of the claimants.
So it was disputed by the insurance company.
It was disputed subsequently by the insurance company on adducing evidence.
So it was proved that the policy, there was no policy.
No, no, no. That I am telling, sir.
Now, what is the findings of the learned judge? Let us see.
Let us. Learned judge passed the order against copy number 1.
No, no, whatever it is, let us see the findings.
Kindly see, page, my lord, kindly 28. 28, last part. Page 28, my lord. Experty against copy number 1 and contest against copy number 2. Amount of reading of the date. Extra আছে কোনটা ডাইরেক্ট সুইটে ঠিক আছে ঠিক আছে footnotes. My lord, kindly.
No, no, let me see the judge.
Right, all right.
Now the question is, vehicle owner appeared in this matter?
Huh?
Vehicle owner appeared in this matter?
Vehicle owner, no.
Page 20.
Yes.
Page 18, I'm sorry, last paragraph. 1-8.
Yes. Yes, what do you say?
My lord, the most surprising thing is that the insurance company did not challenge the policy copy filed by the claimants. Neither in the WS nor the insurance company
is the
did not
written
put any
statement?
question to PW1 claimant.
Oh, insurance company are the best persons who can say whether it is genuine or false. Okay, what is the written statement first of all?
Kindly see it. Page
Page 9, my lord.
Page 9.
Para 7 and 8.
Okay, was not covered by the policy of insurance. Yes, so this is their specific denial.
Now, the evidence of PW1 kindly see. Page 31. 31 হচ্ছে chief, kindly see the cross-examination of PW1 page. Kindly 35, page 35.
Yes.
What is the cross-examination? I do not know whether I have stated right.
No, page 35, cross-examination.
Yes, 36, page 36 kindly.
Yes.
I do not know whether I have stated right by relating issuance of offending vehicle in column number 17 of the petition. I cannot say whether the bus bearing number at the accident was not under policy coverage within as an insurance company. I cannot say. Not a fact that I am entitled to get any compensation. But the insurance, but the policy filed by the on behalf of the claimant,
yes,
they did not challenge because they did not say that this is a fake policy.
They verified that it was not issued by them.
This did not specifically challenge the
nothing in the written statement. They say that they are these
not covered, not covered.
Yes, that is that they have stated. So you have to show that yes, it is covered.
It is also their duty. It is not covered.
You have stated that they have brought the authority.
Kindly see.
So okay, insurance company adduce any evidence?
Yes.
Let us see that.
There I say. Kindly see it. Everything will be disclosed. No.
Page 39.
Page 39.
39. 39. Yes. Kindly go through the evidence, then I will see. দুটো রুলিং এখানে আছে।
Sure.
Yes.
My lord, insurance company, in order to exonerate their liability, they produced 2 pages. What they said that this is the computer generated premium register. Is it possible 2 pages only the register? Where from you know, what is the cross examination? As the my lord, kindly page 42. Kindly page 41st, page 41st. Last para. The computer generated premium register containing 2 pages is marked exhibit B, objected to page and my last para. Page 40.
Page 40.
Last part online.
So this is the policy which we exhibited of which year?
This is the premium policy premium register by the company, 2 pages.
You have relied upon the policy paper. Okay.
I have relied upon
that is of which year? As per issuance issued on in which year?
The year which the accident took place. My policy is covered there.
That is
Accident.
page.
This is in the year 2005. 10/10/2005.
Okay, page 56.
Page. That is page 1. Page 1, page 2, my lord. Huh?
56.
That is the Middleton Street. Issued from Middleton Street, Calcutta.
No, my lord. Page 2 of the claim application.
Policy, page 56.
Oh,
My lord,
policy copy.
Yes, page 56.
Policy copy. 52. 56, my lord. Policy copy 56. Here the period is covered. Now my lord, kindly then go through the page 42.
Yes.
This is the officer cross-examination of the officer of the insurance company. As the number of the vehicles have not been mentioned in exhibit B, policy number of the vehicle is not there. Where from you go to? Which policy? For whose policy? You cannot get it. Only 2 pages premium register. Is it believable story? Then it is not possible on my part. Then he admitted to any which owner or insurer belong to which vehicle. As there is no vehicle number, so which owner on which vehicle he cannot say. It is not a fact that in order to avoid our liability, we manufactured the exhibit B.
Now the question is, you see, this policy is recorded in this.
In order to exonerate their liability, they will have to prove that at that time there is a policy register, premium register.
So this is 2005, 2006.
Yes, Your Honor.
So apart from this place, is there any other place from where the policy can be issued?
No.
So you have stated from Middleton Street. So respondent is of Middleton Street.
It can get, my lord, page 3, claim application 17.
So this is Netaji.
Para 17. National Insurance policy number 101.
Okay, but here it is the address is
same.
Yes, registered office is Middleton Street.
Here also vehicle number is there.
No, that is there. Registered office is Middleton Street. Yes.
Now it was not. It is not a fact that the above stated was stated that by me is not correct. I am not deposing falsely. So from the evidence of DW, it is crystal clear that they failed to prove their premium register or policy is mandatory. In order to prove this is the decision of this High Court. that insurance company had neither specifically about the truck and covered van. They failed to prove that vehicle was not validly insured.
Question is premium register was not produced.
Premium register, or they say this is the premium register. 2 pages containing premium register, where no vehicle number.
Premium register of this 20, no, your policy was 29/8/2005 to 28/8/2006.
Yes, my lord.
Okay, and the accident took place within that period.
Yes, 10/10/2006. So
And
here the insurance company did not produce, only produce 2 pages where there is no vehicle number. Where from you only get that this is the policy of that vehicle? 2 pages containing the register. One register is only 2 pages.
that is page.
I pay suggestion.
No, page.
Page, my lord. 42. Page 42, my lord.
Yes.
2 pages containing page, my lord. Page 40, page 40. Last para, last period. On perusal of which I have deposed on the above statement, the computer generated premium register. This is the computer generated premium register. Of what? Whose premium register? Vehicle number is there. Wherefrom your honor will ascertain that this vehicle was not covered. This is the premium register of this vehicle. Nothing containing 2 pages is marked be objected to. I objected there. So insurance company failed to prove. It honors upon the insurance company to prove. I filed the insurance policy, and that was not challenged by the insurance company. Now the question is, the insurance company notice proceeding did not put any question to the cross claimants, witness or owner. My lord, another thing, this is the decision of the High Court, where the insurance company did not put any question regarding the issuance of issuance of a policy. So it is mandatory. Policy register, premium register is mandatory. I filed the decision of the I also called for the insurance company did not produce the proposal form, which is actually judgment. 1995 to
United versus
United versus Ashok Kumar Rao.
Yes, will you submit today or?
Yes.
হয়ে গেছে না একটা দুটো দিয়ে দিয়েছি তো থেকে This is the decision of the Honorable High Court, where the insurance company did not put any question regarding the issuance of certificate of insurance to the neither the claimant nor any witnesses. This is the reason. This is mandatory. But they did not raise any question. This is a fake policy filed by you. No question was put. Wherefore, my lord will get our policy, only policy. They failed to prove that documents.
Yes, yes, sir. Yes, anything else?
And another thing is the this will not go. This is the attract this section 65 of the Evidence Act. For there is a provision.
Yes, let us see that.
Yes, my lord, see, kindly see. This computer generated policy will not go in this way. This is not the way to take the evidence. There is a procedure, not 65B.
Hey, Degi, criminal,
criminal
Major
procedure.
Acts,
Yes, Evidence Act.
2008 and a civil. No, no, এখানে নেই।
Another thing, insurance company may call for the owner.
ক্রিমিনাল মেজর অ্যাক্টসটা বা এভিডেন্স অ্যাক্টও দেখতে পারেন।
Premium register of insurance policy issued by our company for the period 2985 to this. I pause here for a moment, my lord. This policy, which has been exhibited at page 56, my lord, it is from 29/8/2005 to 28/8/2006.
38.
No, 29 to 28.
Yes, yes.
Yes, that is at page 56.
Yes.
Now, DW2, my lord, he had exhibited that exhibit B at page 64. My lord will kindly come to once. Page 64. Ache, my lord, copy te ache? Paper book?
64, it is not here.
64 is not there.
Up to 62.
These were not there, so he was directed to prepare a supplementary paper book. If my lord has the LCR is there, my lord will kindly. This is a little.
LCR is there, my.
This one is not legible. My lord will kindly see the LCR once. This is for the period of August. The policy, it's from 29th August 2005. Now DW2 produced the register for the period of August. So either the vehicle was insured or it was not insured. That is, this policy is fake then, if it was not insured. For the period of August, my lord will kindly see, it is true that the number of the vehicle had not been given, but the endorsement numbers, that is the policy numbers are there, the name of the owner, it's there. This particular, the name of this particular owner And the policy number mentioned in this policy, my lord, it's not there in that exhibit B.
Premium register.
Yes, that is for the relevant period.
That is computer generated premium register.
Yes, my lord. So if it is not
And
there,
policy registers are also there.
yes, it must be there. But this is computer generated. So if it's not there, this policy number and the name of the owner for August, which as per this policy, my lord, it was valid from 29th of August 2005. That means this policy is fake. That is exactly what the case of insurance company is. Accident may have taken place on 10th of October 2005. But this policy is fake. Learned trial judge took note of this and the evidence adduced by us, thereafter directed the owner to pay who intentionally did not appear in spite of receiving summons. I do not find any error in the judgment passed by the learned trial judge, my lord. It's very well reasoned, I must admit. So exhibit B at the top, my lord will kindly see. It's from 1st of August 2005 to 30th of August 2005.
Exhibit B.
B. It's in the LCR, my lord. It's in the lower court records, my lord will once see. It's legible.
It is not here incorporated.
Because initially these exhibit A and B, it was not part of the paper book. So on the last day, my lord had directed my learned friend to prepare a supplementary paper book. So I have received this. It's part of the LCR if my lord kindly peruses once. In my view, my lord, it's a very well reasoned judgment. There was no policy. Paper LCR. May I, my lord?
Okay, come at 2 p.m.
My lord.
So FMA 1082 of 2009. One appeal is not appearing, it is treated to be in the days list.
Lordship.
Yes, I'm reading out the operative portion. Hence, both FMA 1082 of 2007 and FMA 437 of 2008 stands disposed. The judgment and award dated 21st July 2006 passed by learned Additional District Judge 4th Court Barwan District Purbo Barwan in MSC case number so-and-so stands modified to the extent that the claimants respondents are entitled to compensation of rupees 5 lakh along with interest at the rate of 6% per annum from date of filing claim case till today. The claim amount should be disbursed in the following ratio, which I have stated. The appellant in National Insurance Company Limited shall deposit rupees 5 lakh along with interest at the rate of 6% per annum from date of filing claim case till today. Such deposit shall be made within 8 weeks from the date of communication of this order. In the event amount awarded by learned trial court is deposited, the balance amount be deposited. The claimant's respondents will be entitled to withdraw compensation upon compliance of necessary formalities. Upon depositing the compensation amount, the appellant insurance company will be entitled to recover the compensation amount in accordance with law. Such recovery proceedings may be instituted before the trial court. As the dishonor of check and cancellation of policy is admitted before trial court, separate inquiry by insurance company in this regard is not necessary. However, considering the fact that 20 years have passed and considering the quantum of compensation awarded, this court is of the view that reasonable opportune time should be given to the vehicle owner to pay compensation to the insurance company. Thus, the vehicle owner MS Haryana Transport Corporation is given 3 years' time to pay the entire compensation awarded by equal monthly installments. The monthly installments shall be decided upon discussion between the parties, failing which either party may apply before trial court. In the event there is default of payment of 4 consecutive installments, the insurance company may apply before trial court for execution of entire balance amount.
Grateful to you, Raj.
Yes, hence this appeal. Yes, hence this appeal FMA 1348 of 2024 along with Court 21 of 2025 is disposed. The judgment and award dated 23rd day of July 2024 passed by learned Additional District Judge, First Court Barashat, North 24 Parganas in MSC case number 47 of 2012 stands modified to the extent that the claimant respondent is entitled to rupees 12,50,000 as compensation along with interest at the rate of 6% per annum from date of filing claim case till today. The appellant National Insurance Company Limited shall deposit rupees 12,50,000 along with interest at the rate of 6% per annum before Registrar General High Court Calcutta within 8 weeks from the date of communication of this order. In the event compensation awarded by learned trial court is already deposited, balance amount be deposited. The claimant respondent will be entitled to withdraw the compensation upon compliance of necessary formalities.
Grateful, my lord. The number of the court, my lord, has mentioned is 21, my lord.
Yes. What it should be?
No, I do not know. In my paper book, my lord, it's 225. 225 হবে না. It should be 21, I believe. Maybe he has written
কত আছে 21?
21 তো?
It is treated in the days list.
My lord, my lord. Grateful, my lord.
Yes. Yes. Hence, this appeal FMA 1425 of 2024 stands disposed. Judgment and award dated 29/7/2024 passed by Learned District Judge Nodia in MSC case number 286 of 2016 stands modified to the extent that the claimant's respondents are entitled to rupees 14 lakh along with interest at the rate of 6% per annum from date of filing claim case till today. The respondent, Royal Sundaram Alliance Insurance Company Limited, shall deposit rupees 14 lakh along with interest at the rate of 6% per annum before Registrar General High Court, Calcutta, within 8 weeks from the date of communication of this order. In the event compensation awarded by Learned Trial Court is already paid or deposited, balance amount be deposited. The claimant's respondent will be entitled to withdraw the compensation deposited upon compliance of necessary formalities. Deficit court fees of the enhanced compensation be paid within 4 weeks.
Lordship, kindly FCR send down Learned Court below with special messenger cost.
Yes.
Within 7 days, Lordship. Special messenger cost. আমরা দিয়ে দেব।
LCR be sent back with special messenger cost to be deposited by the respondents.
By the appellant.
By the appellant.
Appellant, Lordship. Within 7 days, Lordship.
Yes. Yes. Yes.
As I was submitting before recess, my lord, page 56, the insurance policy, page 56 of the paper book.
Yes.
In this case, my lord, the relevant date is the date on which the insurance policy was issued, not the date of accident, my lord.
Yes.
Herein, as per this policy, it was issued on 29th of August 2005. Now, my lord will kindly come to page 64. That is Exhibit B.
Exhibit D.
Exhibit B. Exhibit B, my lord. That is for the month of August, and the relevant dates. Page 64 of my paper book, and the first page of Exhibit B. The last entry.
Yes.
The last entry has my lord found it. There are 2 pages. The first page of Exhibit B.
Yes, there is.
Yes, the last entry is my lord 29/8/2005.
It is 29/8.
In my paper book, this is what I had been provided with.
LCR, you see,
my lord.
it is 14/8.
Yes, it's 14/8. There are a number of dates mentioned in this Exhibit B, my lord.
Okay.
For the policies which were issued in that particular month, in August 2005. So this 29/8/2005 policies which were issued on 29/8/2005, my lord, that is in my
29/8/2038/2005 is there.
Yes, before that the
29 to 29/8.
Yes, the number of policies which were issued, my lord, 4 or 5 policies were issued on 29. The references had been provided. The amount of premium, the policy number, all those are here. 15th of August, thereafter 29th it starts.
So the policy numbers and the name of the
Yes,
policy
name of the owner and the policies numbers, they have been provided. In this policy, now my lord will kindly come back to 56. Name of the owner is the insured, it's Shri Krishna Mondol.
Yes.
This name is not there.
Name and policy number is also not telling.
No. So we are concerned with 29th of August 2005, on which this policy, this alleged fake policy had been issued as per my. So neither the name is there. There is one Shaha, Singh, Ojha, Das, Sarkar, Yadav, but no Sri Krishna Mondol. And the number also, my lord, it's not there. So since we are not concerned with the policy, which was, I do not know whether it was issued, not issued, I'm not getting into that. But as far as this policy is concerned, my lord, this is a fake document. And we have given evidence. In our written statement, we have taken the plea. This person from our company, my lord, he had deposed as DW2. He had specifically stated that this vehicle was not insured with us. Learned trial judge dealt with it. And as far as that 65B is concerned, my lord, there was, at the time of cross-examination, my lord, there was no objection by the claimants. It was not raised. Now in appeal, because it goes against him, they come.
Exhibit is the list of the policies.
Exhibit?
List B is the list of the policies.
Yes, which were issued on that particular date, on 29th. So in that day, within those dates, my lord, this particular policy is not there. And since it is computer generated, my lord, there cannot be any other policy because it's computer generated. Now in appeal, my lord, he is coming up with 65B of Evidence Act. It's neither part of his memorandum of appeal, nor any objection was raised when this evidence was taken. Now, learned trial judge, my lord, took note of everything and thereafter directed the owner to pay. He could have easily gone for execution, my lord, against the owner. Nothing stops him from doing that. The observation of the learned trial judge, my lord, it starts at page 18 regarding this, whether owner had appeared or not. And it was discussed in details. And thereafter, it was held that the owner should pay. Since there is no policy, my lord, we cannot be made liable to pay the compensation, my lord, in absence of policy. The vehicle was not insured, it was a fake policy. And we have specifically proved that.
Yes, anything in reply?
My lord, one thing, this is not true. Kindly see page 40 of the paper book where I made objection. Page 40, last.
I was on objection about that 65B. 65B.
Page 40.
Page 40, huh? The generated premium register.
Yes.
Two pages, premium register. I put suggestion also, my lord, kindly see page 42.
Yes.
It is not a fact that in order to avoid our liability, we manufactured the exhibit B. It is my specific suggestion. 2 pages, only no vehicle number, nothing. How can it proved?
The relevant pages, my lord, had been exhibited. If today, my lord, passes an order, and I'll only look for that order for, I mean, today's date. I'll not search for any other date, my lord. It's as simple as that. The relevant pages were exhibited, wherein the number of...
not take any plea in the... then not put any question to the...
saying, my lord, my
PW is a fake policy. No question was put to the not a fake policy.
What
now he is
are
fake
being
policy.
made?
What is the evidence? Where is the evidence? Fake policy? I tell that it is a manufactured policy. I told. But they did not.
I am
put any
grateful
question
to my
to the
lord. My lord,
51.
my lord
There
will
is-
kindly record that he has
No, no.
accepted that it's manufactured.
Yes.
I am grateful to my lord.
All right.
Yes, record. Learned advocates for the parties are present. Are learned advocates for the parties. This appeal is directed against the judgment and award dated 10/9/2013 passed by learned additional district judge, fast track 7th court, Alipur, South 24 Parganas, in MSCC number 134 of 2006. The Clement appellant, being aggrieved by the award dated 10/9/2013, by which the learned trial judge directed the vehicle owner to pay compensation of rupees 1,25,333, and not directing the respondent number 1, National Insurance Company Limited, to pay the same. Learned advocate for the appellant Clement submits that the insurance company did not challenge the policy copy filed by the claimants, neither in the written statement, nor did they put any question to PW1 about the existence of policy. Learned advocate further submits that the insurance company produced the premium registered, which is only 2 pages, where the vehicle number is not mentioned. Thus, it cannot be ascertained as to whether the said vehicle was insured or not. It is also submitted by the learned advocate that the computer-generated slips are required to be proved under Section 65B of the Indian Evidence Act 1872 has not been done in this case. Learned advocate relies upon the following 2 judicial decisions. Divisional Manager Oriental Insurance Company Limited versus S.H. Mehar Singh and another, reported in 2000 ACJ 120, and United India Insurance Company Limited versus Ashok Kumar Raut and others, reported in 1995 2 TSC 548 Odisha. Learned advocate appearing for respondent number 1, National Insurance Company Limited, submits that the insurance company has taken a specific stand that the vehicle was not insured with the said company, and the policy relied upon by the claimant was not issued by the respondent number 1. Learned advocate further submits that by producing the relevant register containing premium received from 29/8/2005, but nowhere the insurance policy number and the name of the vehicle owner appears. It is also submitted that learned trial judge, upon considering the evidence of the insurance company, has rightly directed the vehicle owner to pay the compensation. Upon perusing the written statement submitted by the respondent number 1, National Insurance Company, it appears that there is a specific denial that the policy relied upon by the claimant was not issued by the said insurance company. It further appears that the premium registers which was exhibited by the insurance company did not contain the name of the vehicle owner. It is an admitted position that the policy of insurance was entered into between an insurance company and the vehicle owner. Stop. The claimant who is not a privy to the said contract of insurance cannot have any knowledge. The claimant who is not a privy to the contract of such policy cannot be said to have any personal knowledge about the particulars of the policy. Stop. Thus, when any dispute arises and the insurance company disputes the same, the remedy which was available to the claimant appellant was to examine the vehicle owner, who would be in a best position to say as to whether the said policy was issued, whether a contract of insurance was executed between the respondent number 1, National Insurance Company Limited, and himself. He would be further in a position to give necessary particulars with regard to the policy, as a vehicle owner is always aware about the facts regarding entering into a contract of insurance. Further, as observed by the learned trial judge, the appellant claimant did not examine the regional transport authority, who would be in a position to say as to whether a particular vehicle was covered by any policy of insurance. In the facts and circumstances, this court does not find any error passed by the learned trial judge. Stop. However, considering the fact that motor vehicles claim legislation is a beneficial legislation, and it may be difficult for a vehicle owner to pay the compensation amount, it would be just and reasonable to remit the matter back to the learned trial court, so that a reasonable opportunity is granted to the parties to examine the vehicle owner, the regional transport authority, or such other persons which may be necessary. Thus, this appeal, FMA
1736 of 2000.
FMA 1736 of 2014 stands disposed. The matter is remitted back to the learned trial court to permit the parties to adduce further evidence in terms of this order, and to reconsider the decision of MACC number 134 of 2006. In reconsidering the issue of MACC number 134 of 2006, upon further evidence, the learned trial judge will not be influenced by any order passed by this court and shall decide the same in accordance with law.
I'm deeply obliged, my lord. Only wherein my lord had mentioned the total amount of award, my lord,
Yes.
it will be 4,03,000. My lord will kindly come to page number 27.
27
of the paper book. Second paragraph, fourth line, 3,96,000.
3,76,000.
96,000.
No, it is here. It is Dated
Second paragraph, fourth line,
page
27.
Yes.
Second paragraph, fourth line at the end, 3,96,000.
So I think that the mother of the deceased victim will get rupees 20,000.
Before the paragraph before that, second paragraph.
Yes,
3,96,000, and thereafter the next page, my lord will see page 28. 7,000 on general damages total. Page 28, second paragraph again, in addition to the state compensation.
Yes.
2,000 and 5,000. So it will be 4,03,000.
4,03,000.
I'm deeply obliged, my lord. Extremely grateful.
My lord, kindly the direction may be given to specific period for consideration of the
As the case relates to the year
within a specific time.
2014, as the case relates to the period of 2014,
2006.
2006.
Okay, 2006.
Yes.
The Learned Trial Court is requested to dispose of the claim case expeditiously and preferably within a period of 6 months from the date of communication of this order.
Grateful, my lord.
না ওইটা যেটা বলে দিলাম 3 lakh. Yes, the amount is 3 lakh.
4,03,000.
4,03,000. 4,03,000.
Much more. नहीं काको जमान ना
देखी हाँ again not today. Item 6. Huh? Okay. Item 7.
This is a insurance appeal. This is a death case. An award of 26,22,579.
Yes.
22 lakhs plus principal sum. The award has been passed. The money is secured before your lordship. The matter relates to the death of an advocate, who was a practitioner of High Court. The gentleman was 65 years old. I have assailed this award, on a number of issues. First one is, whether the victim died in the concerned accident or not. With regard to the involvement of the vehicle, that was the first issue. Second issue, whether the injury which had occurred because of this particular accident was, the cause of the death or not. And, thirdly, it was on quantum. When the matter was taken up last by your lordship, perhaps my lord had taken some notes. One
supplementary paper book was also filed.
Yes, supplementary paper book was certain documents.
Data ko the sheet ta je notes ne hoye. Anyway, you submit because you will file written notes after a few days, whatever it is, both of you. You submit whatever you, both of you, because after a few, I shall grant you time to file written notes.
Lordship. First of all, what I say that this.
Oh, note.
And if you submit your written notes, okay, argue and submit your written notes.
Written notes.
No. This type of matters require.
My lord, the points which my learned friend, my lord, will argue, my lord, I will answer, but very short.
No, you see, you said it.
Because there is no, my lord, I shall not rely any judgments. 7 accept 1 judgments, my lord.
Okay.
If there is number of judgments, then the argument will be.
Okay.
The first point what I had raised, it was with regard to the non-involvement of the offending vehicle. The date of accident is 5th of January 2017.
Yes.
If may I, invite your lordship, to page number 5050, the first information report, the written complaint. Whether victim suffered injury by this particular accident or not, this is what I was trying to impress upon your lordship. Page 50. Is my lord there? 5050. 50 is a written complaint on the date of accident itself.
Yes.
The vehicle number is there. There is no dispute with regard to that. But whether this particular victim suffered injury in that particular accident, the name of the victim is not there. This FIR, Milord.
So who is this complainant?
Milord is one.
One Gojo Das.
Gojo Das.
Local person.
Milord, আমি গজো দাস পিতা সো এন্ড সো সংখ্যা থানা এত আজ অনুমানিক রাত 8টায় নাগাদ সাইকেলে রাস্তার উপর যাচ্ছিলাম বিটি
He was waiting and standing.
Milord, he had lost the written complaint. He has not been examined by the claimants, Milord. Milord, this written complaint, Milord, culminated in charge sheet, Milord, which is at page number 52. And Milord, I was inviting my lord to page number 54 of the charge sheet, Milord, running page 54 of this paper book.
Yes.
Milord, charge sheet starts at 52. I was praying your lordship to come to page 54.
Yes.
Brief facts of the case at the bottom, Milord.
Yes.
The fact of the case in brief is that on so and so at around 21:35 hours, one Gojo Das, so and so, of New Barakpur, came at PS and submitted a written complaint to the effect that on so and so at around this time, the complainant going towards BT College more than from Michael Nagar, that time he saw an old man and a young lady were crossing the road. In the charge sheet also, subsequently also I do not find the name of the victim. The name of the victim was Shubir Ranjan Ghosh.
Okay, the victim.
The victim, Milord, the one who was who suffered injury and then subsequently died, Milord. It is not here, Milord. Your lordship will come to the very last paragraph also, Milord. There is one another issue I would, Milord, placing before your lordship. During investigation, the last paragraph of this charge sheet. Is my lord there, Milord?
Yes.
During investigation, my lord is there, Milord, last paragraph. A prima facie charge under section 279 and 338 IPC has been well established. Milord, here, pausing here for the moment, Milord, 279 is rash and negligent driving. 338, Milord, is causing, Milord, injuries. And Milord, the death arising out of the injury, Milord,
340.
That is not here.
Okay.
Whether this, Milord,
so death took place when? Prior to charge sheet or after charge sheet?
Milord, this charge sheet is on 28th February 2012. And Milord,
on 28th
February 2017.
22nd February 2017.
22nd.
28.
Milord, and Lordship.
22.
Milord, even assuming it is 22, Milord, the death was on 31st January 2017, much before this charge sheet. The gentleman, Milord, he died on 31st January 2017, much before this charge sheet was submitted.
31, 1.
31/1/2017.
Yes.
Not much before the submission of this charge sheet. It does not speak, Milord, about this injury leading to death, Milord, or rash and negligent act which led to the death of the victim. Negligent act amounting to culpable homicide. Milord, thereafter, Milord, the victim, Milord, he was allegedly, Milord, he suffered accident on 5th of January 2017. I do not know, Milord, whether in this particular accident he suffered injury or not. I have shown it to your lordship. FIR, written complaint, the charge sheet, Milord, whether he suffered injury or not, Milord. Then, Milord, he was taken to, Milord,
Both FIR and charge sheet does not
reflect his name.
reflect the name.
Lordship. Milord, he was taken to a hospital, and thereafter, Milord, he was discharged from the hospital on 28th January 2017. January 2017. And then, Milord, he died on, as I stated earlier, 31st January 2017. Third day after he being discharged. Milord, there is no post-mortem report. Milord, I am going a step by step, Milord. First of all, whether victim was involved in this particular accident or not, number one. Secondly, assuming he was involved, whether there was any rash and negligent driving on the part of the driver of this vehicle or not. And thirdly, Milord, if I lose on these two grounds, Milord, whether these injury led to his death or not. Because, Milord, 3 days prior to the death, he was discharged from the hospital and there is no post-mortem report.
Yes.
Milord, I'll take a very short time to show your lordship, Milord, and take my lord to the evidence of these, Milord, the point what I'm trying to prove before your lordship. And then thereafter, Milord, there is a small point on quantum. I'll show that also, Milord. Milord, first of all, Milord, I would invite your lordship, Milord, to the evidence of the widow. Milord, this claim case was filed by the widow of this victim, but subsequently she expired, and thereafter, Milord, the daughter substituted her. So at present, Milord, the daughter is before your lordship as the claimant.
Yes. Page.
Milord, the evidence of widow.
14 to 21.
What is that? Milord, the evidence of widow starts at page 14, Milord. I am thankful to my learned friend, Milord. Yes, take a note of that. Your lordship will kindly come to page 21.
Page 21.
Lordship. Cross-examination, Milord. Milord, 6th line from the top.
Yes.
No post-mortem examination of the dead body of my husband was done relating to the police case. My lord, thereafter, your lordship will kindly come, my lord, to the evidence of PW2. My lord, PW2 is an employee of ILS hospital where the victim was taken after the accident. My lord, the evidence of PW2 starts at page number 22. Is my lord there at page 22, my lord?
Yes.
My lord, the evidence starts, my lord, the first para. I am the employee. My lord, second para, this is my authorization letter.
Yes.
And third para, my lord, this is what I was trying to impress upon your lordship. A fostered patient, Subir Ranjan Ghosh, was admitted in ILS Hospital, Damdam on 5th January and was discharged therefrom on 28th January. Similarly, his discharge is confirmed by the hospital authorities. And my lord, the next relevant part, my lord, your lordship will kindly come to the very next page, page number 22A. My lord, from the, I'm sorry, my lord.
Yes.
My lord, cross-examination, last page, my lord, 2 lines extra I would read. Page 22, last sentence, my lord. ILS Hospital, Damdam falls within the territorial jurisdiction of Damdam. Aforesaid Subir Ranjan Ghosh was admitted at our hospital after. My lord, now I'm at page 22. My lord, the very first sentence. Yes, my lord, receiving accidental injury at the top.
Yes.
Receiving accidental injury, and we accordingly informed the local peers about the accident immediately after his admission, but at present I have no document to prove the same. Aforesaid patient, your lordship, this is what your lordship will kindly take note of. Aforesaid patient was discharged from our hospital on 28th January, being recovered. And thereafter, he was never treated at our hospital at Nanda. Well, kindly take a note of this. Mirror hospital comes up before the court and says that Milord, he was discharged on 28th after being recovered. The gentleman died at Milord on 31st at his home. Page 25, Milord, is the eyewitness. Page 23, I'm sorry, Milord. Page 23 is the eyewitness. I'm sorry.
23, yes.
Milord, eyewitness, Milord, in the supplementary affidavit, the cross-examination of eyewitness is there. If my lord is kind enough to take the supplementary, this thin one, Milord. The cross-examination of eyewitnesses in the supplementary paper book, Milord. Which is at page number 3.
PW3.
PW3 is the eyewitness. Yes. I was inviting your lordship to the cross-examination of PW3.
Yes.
My lord, kindly come to the running page 3 of the supplementary, Milord.
Yes.
This is my lord, Milord. Cross-examination. The eyewitness says, I, along with the victim, was on the side of the road. We were not on the footpath. We were not on the footpath. It is not a fact that the accident was caused due to the fault of the driver of the vehicle number so and so. It was not on the fault of the driver. So, Milord, even assuming, Milord, on the
Yes.
My lord, hypothetically, my lord, even assuming that I lose on the first count with regard to his injury arising out of this accident, I'll lose on the second count, my lord, that he did not die because of this accident. My lord, third count, rash and negligent driving of the driver of the offending vehicle, my lord, has been denied by the eyewitness in the cross-examination. And the charge sheet also does not refer to, my lord, section 304A, which has been filed, my lord, nearly a month after the death of the victim. My lord, these are the 3 points, my lord, as far as, my lord, this involvement, the injury, which can be related to this particular accident, and death arising out of this particular accident, my lord, are being disputed by my client before your lordship. My lord, your lordship knows, my lord, in a proceeding under section 166, my lord, I need not be troubling your lordship, my lord, with a large number of judgments where proving of rash and negligent driving is mandatory. There are innumerable judgments, my lord, all three judges bench. At least 10 I can cite, my lord, here and now. But, my lord, I am not troubling because proving of rash and negligent driving in a proceeding under 166 is mandatory. Your lordship knows that. And here, my lord, I have got shown your lordship, my lord, two specific, my lord, reasons. One by the police authorities, my lord, who do not slap section 300.
You may cite any one decision, and you're not necessary to cite, you give the copy.
My lord,
any one decision.
My lord, Sunil Kumar, Reshma Kumari.
Oh, that is there.
Three judges bench, all three judges bench, my lord. All. This, my lord, is starting from Pratham judgment, the three judges bench. No. Prema Bhai Patel, no, 71 judgment এটা ছিল. Minu Bhai, three judges bench, my lord, which originated that yes, it is absolute, it is sine qua non to claim compensation under 166, my lord. There is no dispute about that. So, my lord, my lord, there are very various, my lord, various. My lord, so on these three,
this is the only eyewitness.
This is the only eyewitness, my lord. So on these three issues, my lord, I say that, my lord, my client is not liable to make payment at all. My lord, thereafter, my lord, I'll go, my lord, I am not traveling a lordship, my lord, with the other irrelevant pages of this paper book, my lord, which is not connected with my ground of appeal. My lord, as far as the quantum is concerned, my lord, the income tax authorities came up before the learned tribunal. My lord, they showed and they filed, my lord, the income tax return. The learned tribunal, my lord,
yes,
on the basis of last income tax return, considered yearly income of the victim at rupees 4,16,015, 4,16,015. My lord, I'll just show, my lord, the income tax return, income tax officers evidence to your lordship. This is at page 29 of my lord's paper book.
Yes, it was considered as rupees.
My lord, 4,16,015. This was the income which was considered by the learned tribunal for assessing. My lord, this has been shown to be correct income by the income tax officer. But my lord, I'll come to the point why I join issues here. My lord, may I pray before your lordship to come to page number 29 of my lord's paper book. Page 29, my lord, is the income tax officer's evidence.
Yes.
My lord, the very last paragraph of this page is relevant. The ITR, is my lord there?
Yes.
The ITR of 2015-16 is shown to the witness. The professional income has been rupees 341,075. Income from other sources 74,940. But when these two are clubbed together, then this figure of 416,015 comes in. But I join issues here that 74,940 was not the loss of income to the claimant. But I'll show your lordship how and why. I'll continue further. Income from other sources include income from bank interest,
Yes.
My lord, I just read the line again, my lord. Income from other sources, my lord, that is 74,940. That is what, my lord, is troubling me. Income from other sources include income from bank interest, investment, etc., except salary and capital gain. The total amount tax was nil. Absolutely correct. My lord, this has been substantiated at page number 270, my lord.
From the return itself.
From the return itself, my lord, I'll just show the return part, my lord, so that page 278 to be precise. Page 278, my lord. This year's return 15-16 return starts at 270. My lord, the relevant page is at page 278. This is my lord, there, my lord, 278. But this is the continuation. It starts from 270, this entire income tax return for that particular financial year. I was inviting my lord to 278.
Yes.
My lord, 278, my lord, on the right side, your lordship will kindly see, my lord. The first figure, I, profit and gains from business other than speculation business and specified business, 341,075.
Yes.
My lord, 341,075, which, my lord, is confirmed by the evidence of, my lord, the income tax officer. And thereafter, if your lordship will kindly, my lord, come down in that very page, item number, my lord, 5A, 74940. My lord, after 341,075, after, my lord, 10-11 lines.
Yes.
My lord, this is income from other sources, from sources other than from owning my lord, race horses, and income chargeable to tax at special rates, 74940. What income is this, my lord? I'll substantiate, my lord, if my lord kindly comes to page 292. Page 292, my lord, is there, my lord? My lord, on the left, your lordship will kindly see, my lord, that black box, second black box, schedule OS. On the left?
No, right.
My lord,
Page
no.
292.
Page 292, my lord, there are.
Okay, schedule OS.
Yes, my lord. First is note, second is schedule OS.
Yes, income from
1B. Interest gross, 74940. My lord, this is the income. This is from the interest. Lord, I am pinpointing that from where this income is coming.
7,49,000.
No, my lord, 74,940.
Oh, 74,940.
My lord, this is what, my lord, if your lordship tallies this from page 278 and the evidence of the income tax officer, page 29. That, my lord, income is divided into two parts. My lord, one is, my lord, income from profession of or the otherwise, my lord, whatever he was earning, and then 74940. This is interest income. Income from interest. My lord, as I said earlier, my lord, I am only disputing this 74940 on the quantum side. My lord, once a person dies, my lord, this 74940, my lord, is his heirs or heir would keep on receiving. There is no loss of this 74940. Other professional income, there is a loss. I accept that. And I wouldn't be arguing on that part. But this 74940 is exclusively from interest. This is what, my lord, I have shown to your lordship from the return itself. And this is what I say, my lord, whether the disease remains or disease does not remain, my lord, this 74940 would not be disturbed. That is why, my lord, this has to be deleted at the time of making assessment of compensation from the total, my lord, loss of dependency. Learned tribunal judge, my lord, added these two. This, my lord, 341,075 plus 74,940. 940, what I had shown to your lordship. And by clubbing these two together, my lord, the total income of my lord 4,11,000, 4,16,000 came up. I say, my lord, this 7,4 has to be deleted from that part because there would never be loss of this particular income. This is only for the interest income, and this the claimants would keep on receiving every year. My lord, these are the grounds, my lord, on which, my lord, I have come up before your lordship. My lord, lastly, my lord, interest was granted at the rate of 8%. It should be 6%, what my lord is giving uniformly. So, my lord, I conclude my submissions today, my lord. On these issues, I say, my lord, victim did not suffer injury in this particular accident. If he suffered injury at all, then, my lord, he did not die because of this injury. Number 3, even if assuming he died because of this injury, my lord, there was no rash and negligent driving on the part of the driver of the offending vehicle, which is proven, my lord, by the police as well as the eyewitness. And lastly, my lord, as far as the quantum part is concerned, this interest income, my lord, has to be deducted because there is no loss of dependency with regard to the part of interest. As far as the other income of victim was concerned, my lord, I concede that yes, that was his day. That is the income tax return officer has come up. I'm extremely grateful to your lordship.
Yes. Now, my lord, I'm starting, my lord. First I start, my lord, the nutshell of my case, my lord. My lord, the learned advocate of our High Court, while he was returning from this court to his residence on 5th January 2020, 2027. My lord, while he was in 19 November, my lord, is a crossing, my lord. He, along with her clerk, my lord, just crossed the, my lord, the crossing. At that time, on Maruti, my lord, without following the, my lord, signal, my lord, going and, my lord, the, my lord, my clients, and also, my lord, his clerk. And subsequently, my lord, due to, my lord, the hitting of my clients, my lord, that is should be not done, my lord, the was taken to the local hospital, and considering his seriousness, he was ultimately taken to the ILS hospital. While he was admitted, on 5th January 2017. And continuous treatment was going on. And total amount, near about 6,47,000 was paid.
So anyway, with regard to the medical expenses, it is not under challenge, okay?
Medical expenses. I'm
Neither you have challenged that.
I'm collecting the accidental injury, rash and negligence driving, involvement of the vehicle or my learned friends, and thereafter, my lord, I am coming the quantum. Now, my learned friends, my lord, first point is that my lord, the victim name was not mentioned, the FIR and the charge sheet. My lord, the FIR was lodged at 10 p.m. One Gojo Das. My lord, he was examined by the investigating officers. And also, my lord, the wife of the deceased also examined, my lord. That was reflected in the charge sheet. And, my lord, the claim case was filed by his wife. Because at that time, my lord, the daughter was living, my lord, at my lord abroad. Now, my lord, the question is, my lord, the name of the my lord, the victim should be, my lord, in the FIR or the charge sheet is written or not, name of the vaccine. My lord, your lordship's mother has given recent judgment while sitting in Balan in Jalpaiguri bench following a Supreme Court. But there is no eyewitness. But charge sheet was filed. The charge sheet is must suffice to establish the rash and negligent driving of the offending victim. And the involvement of the mother, the victim also mother, inferred from the mother, the evidence of the mother. Malad, first Malad, the PW1, Malad deposed, Malad, his wife, the victim wife, that is Malad, Gopa Ghosh. And after Malad, her depositions, Malad, she died. And in her place, Malad, her daughter Annesha Ghosh, now the present respondent before you, she was substituted and came Malad. Now, Malad, there are 4 Malad witnesses, Malad, from the side of the claimants, Malad, and the side of the respondents. That is Malad, Gopa Ghosh, that was she was not sorry. Second is Shuken Mukherjee. He was the Malad, the employee of ILS hospital who proved the Malad, the discharge summary. What the discharge summary says, Malad, this patient was admitted due to the motor accident, RTA. Malad, if your lordship kindly see my supplementary affidavit, a supplementary paper book. Kindly have a look, my lord. My lord, supplementary paper book, page 1. Chief complaints. Page? My lord, page 1 of my supplementary. Yes. I mean, it was discharge summary which was proved by the PWC, the PW2 Shuken Mukherjee. Chief complaint, the alleged my lord, HO, RTA, road traffic accident. By speeding.
That is page 1.
Page 1. That is the manner the just this is a summary issued by the ILS hospital. Page 1, not manner thick paper book. This is my supplementary paper.
The main paper book.
No. Supplementary paper.
Yes, page 1.
Alleged page 1, manner middle portion chief complaints. Alleged HO RTA, road traffic accident by speeding vehicle before 8 p.m. today. He was recovered from his spot in unconscious state. My lord, he was, my lord, brought to the ILS hospital as a unconscious. Until 28, my lord, he, my lord, remained, my lord, unconscious. And why, my lord, he was discharged? Because due to these some monetary problems, my lord, already already 6,47,000 have been got. And my lord, doctors opines that this stage, my lord, the rice tube, my lord, the many tubes, my lord, are in his body. He had unconscious, in the unconscious stage, he was brought to his house on 28th. And 28th, that this summary that you are seeing, that is 21 January 2017 is the discharge summary, which reflects that the patient was admitted due to road traffic accident. So, my lord, my learned friends, my lord, the grounds that it is not a case, my lord, the victim has not faced the road accident. These documentary evidence, even if, my lord, the evidence of, my lord, the law clerk says that my child faced a motor accident, and due to motor accident, he, my lord, got, my lord, severe injuries, and he was taken to the, my lord, the local hospital. Thereafter, due to serious illness, my lord, he was taken to IRS hospital. That was reflected from his, my lord, from the, my lord, the victim's, my lord, law clerk, who she was accompanied by the, my lord, the 1, 2, 3 points are more or less, my lord, interlinked, my lord. That is the involvement of the victim, the rashness, negligent driving of the victim, and the FIR charge sheet does not, my lord, reflect the name of the victim. My lord, if you, my lord, sees my paper book, my lord, the FIR, the victim number was there. And, my lord, in the FIR, my lord, if your lordship kindly see the contents of FIR. My lord, page 48 to 49. My lord, of the thick paper book. Your lordship kindly turn to yes, page 50, your lordship kindly. But the vehicle number was there. And, my lord, this was, my lord, lodged by one Gajadas. He was examined by the investigating officer. And, my lord, may I read, my lord? I Gajadas Pita so aaj anumanik raat 8টা, that was reflected in the discharge summary. আর 8টা নাগাদ মাইকেল নগর রাস্তার উপর থেকে বিটি রোড কলেজে যাচ্ছিলাম, যাওয়ার পথে শেয়ার পাঞ্জাব এর উপর থেকে একটি কম বয়স্ক মেয়ে, দ্যাট ইজ দি ক্লাব, ও একটি বেশি বয়স্ক লোক রাস্তার এপারে আসছিল। তখন বারাসত থেকে দমদমগামী একটি মারুতি ভ্যান, যার নম্বর, in the FIR, the vehicle number here. Yeah.
No, after how many days FIR was lodged?
On the same day.
Same day.
Same day. The accident took place on 5th, and the 5th, your lordship kindly see in the manner, the airport PS case number on 5th January 2017 under section 279 338. Now, my lord, your lordship, my queries is why 304A. My lord, 279 says rash and negligence driving.
No, 304A was not added.
No, 279 and 338.
No, 304A after the date was added.
Date was not added because date was, my lord, a person who died in a manner in a residence, my lord. My lord, may I put a question, my lord? If, my lord, a advocate, my lord. After his long treatment, my lord, he was brought to his, my lord, brought to his house because his, my lord, no change, the unconsciousness. And just after 28th, he was brought to his residence, and 31st, he died. Just after 2 days. My lord, anybody of his family, my lord, send the that body to the, my lord, to the morgue for his postmortem. Kindly appreciate the, my lord, the practical things. Simplicity, my lord, he was brought to the burning, my lord, the cart. And my lord, the Motor Vehicle Act relating and also Motor Vehicles rule says that disposal of a claim case is either postmortem report.
In a particular case, you see, during COVID period,
Yes.
the person was injured and he died in hospital. Then during COVID period, no postmortem was held. But the investigating officer added 304A.
Yes, I'm grateful to madam. Extremely
That is,
grateful to your lordship.
that is the thing.
My lord, I have no experience, my lord.
In
but-
another case, I just found.
But this is, my lord, before COVID. My lord, here it is, my lord, admittedly postmortem was not held because he died in his residence, and he went. My lord, his body was brought to the, my lord, burning cart for his, my lord, burning. And the burning certificate, death certificate has been produced and marked as exhibit. That is suffice as per the motor vehicles rules. My lord, for disposal of a claim case, either postmortem report or death certificate, whichever, my lord, is required, that may be suffice. If your lordship sees, my lord, the rules are there. Lordship, kindly. My lord, there are, my lord, 5 documents required as per Rule 339. Though it is 140. The registration certificate of motor vehicle, insurance certificate of policy, Panchanama or first information report, postmortem report or death certificate, or certificate for injury from the medical officer. These are the rules, my lord, that was guided by the, my lord, Motor Accident Claims Tribunal. As per Rule, my lord, 339, my lord, we produce, my lord, the burning certificate, death certificate before the
Central or the West Bengal? Central.
Oh no, West Bengal Motor Vehicles.
Okay.
That was by virtue of, my lord, 1988, by virtue of section 175 or 6. My lord, these, my lord, rules have been, my lord, framed. Rule 339. 161. Now, my lord, question of that the, my lord, the victim was at all faced the accident or not. If there is, my lord, any, my lord, doubtness, my lord, your lordship is knows that New India, my lord, the New India Assurance Company versus Gita Samunto. Involvement of the vehicle or the ration negligence driving of the vehicle or the, my lord, the accident of the victim, all, my lord, seized by, my lord, the division bench decided over by his lordship the Honorable Justice Bhaskar reported this that New India Assurance Company, Gita Samunto. If the insurance company, my lord, takes leave under section 170, in spite of taking leave from the tribunal, if they do not produce the, my lord, the owner or the, my lord, the driver of the vehicle, it can be inferred that the vehicle was involved, there was a rash and negligence of the vehicle, and there was the accident. It was settled, and while it was followed by, my lord, by subsequent the division bench judgments
of our High Court. On judgment, I have got the Shormishta Sikar, where it appears. The decided to what Dipanko Dutt and Pratik Prakash. He also, but their lordship also reiterated the judgment of Nita Sabha. Where my lord, the categorically says why the driver and owner have not been brought to the manor by the insurance company. It can be inferred that the victim manor was in the accident.
So here the owner contested the case.
Yeah, no, owner has not contested. Even if manor the insurance company has not summoned the owner or driver, manor the insurance company has its manor.
Anyway, that is with regard to involvement, okay?
Involvement.
That is with, if there, here you see,
And manor the
no, involvement is there, okay? Only thing is rash and negligent driving.
Rash and negligence, your lordship is your lordship passed the very recently judgment.
That is the question there, rash, that is rash and negligent driving.
Says that one Mukunda now, one Mukunda. Balat, if your lordship sees Balat the contents of the charge sheet,
161 statement of
Balat, the charge sheet Balat at page at page 52 to 55 of thick paper book.
Yes, page 55, page 54.
Page 54. Now, my lord, I will be permitted to read the middle portions or the fact of the briefcase, the bottom, so and so, one Gojodas, so and so, submitted written complaint to the effect that on 5th January 2000, around 10 at 20, the complaint going to us BT College Mall, Michael Nagar. At that time, we saw a old man, a lady. Old man, that is my lord, the Shubiranjan Ghosh, the advocate of our High Court, was crossing the road near Sheri Punjab. At that time, Maruti van bearing number. There also the Maruti van number is there. The affidavit 52J40 was coming from Barasat towards Domnon side. So and so. On the basis of the complaint, the case has been being started. IAS Rajiv Kumar Singh took up the investigation of the case. During investigation, visited by the PO, prepared Malad with the examined witness and recorded their this statement under section 161 of CRP. And arrested the accused Mukundo Gao, so and Maruti van drivers. And the accused Malad Mukundo Gai was established, Malad, that is 279 338 IPC has well established against the charge sheet is against the driver of the Malad the Maruti van. That was reflected Malad in the charge sheet. And considering 161 statement, your lordship kindly see, my lord, that page, my lord, what are the witnesses, my lord, during investigation, the IO has examined. My lord, column number 4, your lordship kindly see top, page 54.
Yes, Gojodas.
Gopa Ghosh.
No, Gojodas.
And also
page 54.
Page 54 of my paper book.
Yes, page 54 is this. That is complainant Gojodas, then Gojen Mundol.
Gopa Ghosh.
No, complainant.
161 say Gopa Ghosh, wife of Shubiranjan Ghosh of so and so.
Okay, that is 4, serial number 4.
Gopa Ghosh. And my lord, the complainant also, my lord, Gajodas.
Yes.
He was also, my lord, examined. Complainant Gajodas, so to Gajen Mondol, son. So the complainant, my lord, also examined, and Gopal Ghosh, he was the first, my lord, my lord, the claimant. Wife of the Shubhi Ranjan Ghosh was examined after considering the, my lord, the 161 statements, my lord, the IO had submitted the charge sheet where the accused driver was established as a, my lord, responsible and a criminal case under section 338 and, my lord, and 279. 279, 338 IPC has been, my lord. So, my lord, it was admitted that the accused driver was, my lord, allegedly caused the accident. There was a rash and negligence.
After how many days from the charge sheet the claim case was filed?
My lord, claim case was filed, my lord, after the claim case was filed 2017. How many days? Yes, my lord. রেকর্ড থেকে দেখা যাবে just
Charge sheet submitted 28/2/2017.
and my lord,
Complaint case, this is a claim case?
claim case was, my lord, 2017.
17.
And my lord, the date was occurred on, my lord, on 30th, just after 28 days, my lord, the charge sheet was submitted. Before that, my lord, the IO, my lord, had taken the 161 statement from Gopal Ghosh and the, my lord, the Gajodas. And also, my lord, spot verification was done and other witnesses were also evidence, and thereafter he filed. So, and also, my lord, it reflects, my lord, from the discharge summary that the victim, the Shubhi Ranjan Ghosh, was admitted due to the road traffic accident. So there was an accident, there was a rash and negligent driving, there was the involvement of the offending victim, and the victim, my lord, the Shubhi Ranjan Ghosh, was allegedly, my lord, he faced the motor accident. On the date of accident, he was admitted in the IRS hospital, and, my lord, after, my lord, prolonged treatment as the unconscious, my lord, doctor says, my lord, there will be no improvement. Better you, my lord, to the, my lord, him to his house. And on 28th, my lord, he was, my lord, brought to his house, and just after 2 days, he died at his residence. So, my lord, no postmortem was there. But the death burning our certificate that was reflected, my lord, at page
Yes, page 58.
Page 58. The certificate copy of death certificate of the deceased. Now, my lord, by learned field queries, my lord, that 304A case has not been. My lord, may I put a question? Your lordship is aware. My lord, this same case, my lord, under the, my lord, unofficial social welfare beneficiary, any occasion suit case is not a case, just like manner criminal trial followed or civil manner trial followed. This is summary procedure. My client has filed the FIR, seizure list, charge sheet, manner death certificate, sufficient. And manner the vehicles, manner the particulars, the insurance policy, everything EVD, my lord, he produced, my lord, my lord, from the side of the claimant, the 4 witnesses were produced. And my lord, only my lord, witnesses was produced or adduced, no document. Only my lord, one oral evidence was produced by the insurance company, that is I. Who proved?
That is page?
Page, my lord, your lordship kindly see page, page 29. Page 29.
Yes. Page 29 is?
Page
No,
29.
this is income tax officer.
Income tax officer. That is, my lord, that is their evidence.
No, this is your witness. Oh, this is DW.
No, my lord, the driver or the owner, my lord, has been brought or the summoned to prove that the person who died in a motor accident, your lordship is, my lord, is award, this Pushpa Vice case, many cases. It was the duty of the, my lord, insurance company to prove the rationalness or improperly appeal. If, my lord, the driver, my lord, the owner has been withered, that is also Mita Samuntro. It may be in fact that on that day the vehicle was involved and on that day the victim is the motor accident. I need not reiterate, my lord, the same thing, my lord, your lordship passed several judgments, my lord. Now, with regard to, my lord, the quantum, your lordship kindly see, my lord, the income tax return. My lord, the learned tribunal judge has made, my lord, assessment on the basis of the income that was reflected at page 278. On kindly see page 278. My lord, column, my lord, in the left hand side, column number 6. His total income is 1 plus, your lordship got it, is 270. That is the, my lord, the income tax return, my lord.
Yes.
My lord, the column number 6, total income, 1 plus 2 plus 3, 1, 4 plus 4C plus 5D. My lord, it comes, my lord, total is 4,16,050. My lord, my learned friend raised that the interest coming from the, my lord, the fixed deposit or eto will not be, my lord, counted. It would be. This is also income. This is not a, my lord, taxable. Taxable income, my lord, that was my lord, that in I made up my mind that this portion of the money will be, my lord, in the bank for making the fixed deposit, earning something. That was my earning. It is not a case that it should be excluded from my income. So my learned friend Smiler says that 4,16,050.
No, the question you raised is, you see, when an advocate passes away, that cannot be substituted by any members of the family. Okay, advocate or doctor. There is no alternative. No question of any compassionate appointment but so far the advocates, this MIS or postal deposits are concerned, those income continues. Those income, there is no loss of income.
Supposing Malad for his treatment.
Yes.
Because of lack of money, Malad, he was discharged from the hospital. That fixed deposit, Malad, goes. Malad, that is his income, Malad, during the financial of 2015-16 or 16-17. that Malad, before his death, Malad, the ITR along with the Malad, the statements of the ITR has been submitted, and it was proved by their by their witnesses, that is PW by DW1. Any judgment, learned friend says that the income from the fixed deposit will be deducted from the earning income. Only deductible income is the taxable, the professional tax or the income tax. If the person who is the profession here the victim was a advocate. He was in a not self-employed, he is a professional man. He was earning. And the multiplier which the tribunal used, is correctly applied as per the the Sharra Verma. Only thing is, originally, though my client has not filed any cross-examination, only general damage 15,000 and 15,000. But if your losses, follow the chronology, and your losses is delivering the judgment in year 2016, it would be 15,000, it would be 18,100.
Anyway, no cross objection, so no use of going into that. Anything else?
Then, I will not place any.
Then cross objection of with regard to that.
Your lordship applying the law.
No, cross objection of this PW2. Sorry, cross examination.
Cross examination of
PW2, that is the clerk of the advocate.
yes. It was said
PW3, my lord.
PW3.
PW3, the clerk of the advocate.
Yes.
Page 24A. No.
No, supplementary.
Supplementary paper. Page 3.
Yes.
Was the cross examination of PW3, that is Pune Maharaj. I, along with the victim, was on the side of the road. We were not on the footpath because at the time, they are crossing the road. It is not a fact that the accident was caused due to the fault of the. It is not a fact. So it is a fact.
No. That the accident was.
It is not a fact that the accident was caused.
Not. It should have been the accident was not caused due to the fault of the driver. The suggestion was that the accident was not caused due to the fault of the driver. That was the suggestion. So it is stated it is not a fact.
It is not a fact that the accident was caused due to the fault of the driver of the vehicle. Then Malad says it is not a fact that the victim was responsible.
Okay, how did the learned trial judge deal with this thing, PW?
Yes. Malad, your lordship, kindly turn to the supplementary paper book, judgment. I have also annexed. Malad, issue number. Malad, the supplementary paper book. Malad, at page 9. Page 8. Issue number 2 and 3. Issue number 2 and 3 says, did the victim Shubhiranjan Ghosh died in a motor accident? And issue number 3, where the alleged accident took place due to rational negligence. Now, all 2 and 3 issues dealt with at page 7 by the tribunal.
Yes.
These two interconnected issues are taken up together for the discussion. It is the case of the claimant that often he became rational negligence. The red traffic light and hit the victim of the vulnerable. The victim was asked to make after the accident. and then he was admitted until the victim was discharged and confined to bed. Finally, after 2 days, 31st January, discharged from the hospital. The victim died PWD. Who was the victim's law clerk has stated in her evidence on affidavit that she was with the victim at the time of accident and also sustained injuries along with the victim. She has corroborated the case of the claimant as regards the rashness of the driver of the offending victim. There is nothing in the cross-examination to disbelieve her testimony. In addition, the claimant has filed subsequent copies of FIR. That decision, if there was no eyewitness, if the claimant PWC is ignored, the charge sheet says that there is a ration incident driving of the driver of the Maruti van. The FIR airport PS case cover, which has been marked as Exhibit 1, is the police on completion of the investigation has calculated the act of the driver of the offending was ration negligence and that for the accident. Thus, the issue number 3 is decided in favor of the claimant. The ration negligence of the act of the driver of the offending has caused the accident. It is worth mentioning that the driver of the offending vehicle are also the owner of the vehicle. The police, however, has submitted charge sheet against the driver of the so-and-so section for the death by criminal negligence has not been charge sheet filed against the driver of the landed advocate for the insurance company have argued that the death of the victim was not on account of the correction. He laid a twofold argument. First, the victim's death was not unnatural, for he was discharged from the hospital. Secondly, the charge sheet was not 304A, which forfeits the case of the insurance company that the death of the victim was not due to the accident. The landed advocate for the course of argument, however, did not dispute the fact that the victim did made the accident on the given date, time, place of the victim was involved in the accident. In fact, after submission of the charge sheet, there was not much scope for insurance company to dispute the fact the offending vehicle was indeed involved in the accident of the victim. In the absence of any proof of the contrary, it has been sufficiently proved for the purpose of this case that the offending vehicle was involved in the accident of the victim. Now the question to be decided is whether the victim that was dealt with, that was discussed by the time. So, issue number 4 also, FIR charge sheet considers, stranger was not supposed to come, to make a, the file a charge sheet. Charge sheet was filed by the officer. So, the 4 points which my learned are the name of the victim does not appear in the FIR charge sheet. That was I have given answer. 4th point is that no postmortem. I say that from Motor Vehicle Act and rules, it was says that for adjudication of the claim case, either postmortem report or death certificate. And regarding 4th point is the exclusion of that the fixed deposit interest. That was not relevant because that was also earning. Fixed deposit in interest, if that income he was earning, if the victim would have been alive, he would get automatically earn that income. So income is which reflects the the income tax return along with this is my submission.
Yes, Milord, one line rejoinder, Milord. One line rejoinder, Milord. Just to conclude, Milord. Your Lordship has gone through page number 34, Milord, which was just read out. Milord, Your Lordship is supplementary paper book or the main, Milord?
Supplementary.
Supplementary, Milord.
Oh,
Internal,
34.
internal page 5 of the award.
Yes.
Internal page 5 of the award, Milord.
Legally presented.
Milord, 3rd line. There is nothing, my Lord, is there? There is nothing in the cross-examination to disbelieve her testimony. Milord, cross-examination is very specific. What recording is this? Perhaps the learned tribunal judge did not even go through the cross-examination at all. This is one aspect. This is all wrong recording in the award itself, my lord, on the face of it. Secondly, my lord, if I can invite my lord, on the basis of submission, my lord, which was made from the bar, my lord, it was stated time and again that they were not in a proper financial condition, so my lord, they had to bring the victim back to the home. My lord, this was perhaps, my lord, told to your lordship. Your lordship will kindly come, my lord, to page number 25, the evidence of, my lord, the thick paper book, my lord. Page 25.
Yes.
Lord, this is the evidence of the daughter who is today present before your lordship. I mean, today is the claimant before your lordship. Your lordship will kindly come, Lord, to page number 26.
Yes.
Number 6, that I am the only daughter and my father sent me to abroad for higher studies. And the next one, 7,
Yes.
that my father has sufficient income, not less than rupees 40 lakhs per annum from profession.
Yes.
And my lord, the statement is being made time and again, my lord, to get the sympathy of the court that he didn't have the money. That is why he had to take out from the hospital for bill of 6 lakhs. And father was earning 40 lakhs, which is not supported by the document. And the statements are being, my lord, thrown away from the bar.
Anyway, from income tax document, whatever
My lord,
it is.
I am saying, my lord, how the sympathy of
40
the
lakh, that has come to 4 lakh. Okay.
I am extremely grateful to your lordship. My lord, rather 3,71,000.
Yes.
Because of the, my lord, the lesser part, my lord, your lordship, and my lord, as far as, my lord, this charge sheet, that particular page is concerned, my lord, what I submit, page 54, my lord has time and again gone through page 54.
Yes.
My lord, in spite of taking all evidence, in spite of making 161, in spite of, my lord, naming the, my lord, the persons who were there, who were not there, still 304A was not applied. Everything taken into consideration. I'm thankful to my learned friend that he has shown that yes, these were there, these were there, these were there.
304A not given, and
yes,
the name of the victim not mentioned.
Name of the victim not mentioned, and rash and negligent driving denied. And this is before COVID.
Yes, record an order.
Get put to.
Learned advocates for the parties are present. Are learned advocates. The hearing is concluded. Let this matter appear for judgment on 1/8/2026.
I'm thankful to my learned friend, my lord, to your lordship, my lord, for giving me opportunity. And I'm thankful also, my lord, for lordship taking note of everything that, my lord, the statement being made, my lord, in the court, and, my lord, what is being shown from the, my lord, evidence. For 40 lakhs, it is coming down to 4 lakhs. Oh, bless your lordship. My lord is fixing up, my lord, a particular date.
Yes, judgment on 1st of August.
1st of August. Extremely grateful to your lordship.
ঠিক করে দেবেন এটা কাগজটা। আচ্ছা, আর আছে?
And for the appellant.
The matter was heard earlier.
No. Lordship, this is very simple, not taken, I think, 5-7 minutes.
August is the date is Saturday.
Yes, working day.
Working day, that day.
বলবো না কি বলবো সেটা তো বলবেন আমার 5 মিনিট লাগবে
দেখি রেকর্ড পেপার বুকটা দেখি।
Main difficulty is the affidavit in chief of the PW1 or PW2 is not incorporated.
Now the question is first, is it 163 or 166?
6.
166.
Yes.
Lordship, fact is that learned tribunal judge did not consider Lordship future possible.
Very well. Have you incorporated everything in your paper book?
Yes, Lordship.
So why is your learned friend disputing that?
Cross examination is there.
No. All documents have to incorporate. Better prepare a supplementary paper book.
Lordship, affidavit in chief, it's not with me. That's why not. But
Has the trial court records come?
Lordship, every document is there.
No. Has the trial court records come?
I think.
Acha. Recorded learned advocates for the parties are present. Let the documents not incorporated in the paper book be incorporated in the supplementary paper book. Let this matter appear on.
That my landed only affidavit in chief. That is not so this paper. Then another day fixed, he will my lordship 3,000 considered, like 3,000 in consider, and he was a lordship,
দেখুন তো ডেট কবে আছে ডেট, হ্যাঁ তার আগে দেখুন।
another day fixed, but paper book is not necessary. My landed
Oh, paper book you have not, main paper book you have prepared.
lordship. So only
You just verify, please. Whatever is not there, if they, otherwise there will be problem. I have to adjourn the matter again.
lordship, I will not trouble your lordship because only.
Oh, these things will cause the trouble, these missing documents.
No, lordship, affidavit in chief,
যে ডেটটা দেখুন ডেটটা,
page.
হ্যাঁ ও 30th July 2026 at 10:30 AM.
Lordship, then he will observe this and then.
Huh? Learned advocates for the parties are present. Hard learned advocates, as some documents are missing from the paper book. Learned advocates for the appellant is requested to incorporate the same in a supplementary.
Observe the same. Lordship, then another certified copy with John thereafter.
No, you just verify and incorporate
No.
in the supplementary paper book. You just verify the record and just incorporate. Let this matter appear on 30th July 2026 at 10:30 AM.
বলবেন অনেক বলবেন দেখে অনেক বলবেন
only quantum, your lordship. Only quantum.
Yes, 9. You are for the appellant. রেকর্ডটা দেখি। দেখি। Yes, you are for the insurance company. Yes, what is the ground of challenge?
Yes, my lord, quantum. Quantum mainly, my lord, income. Mainly income. Lordship, my lord, kindly come to my lord. Page 36. Page 36. Inner page 7. That is the inner page 7 of the award. Lordship, got it, my lord?
Yes, page 36.
Page 36, number 7, my lord, third paragraph. Then the start PW1. The PW1 stated in her claim petition as well as in her cross-examination in examination chief that victim was the employee of Rockwell Resource Earth Movers Private Limited and used to earn rupees 21,052 per month. The salary slips of the victim were produced for the month of November 2018, December 2018, January 2019, from which it appears that gross income of the victim was rupees 16,719. 21,151 and 21,052 respectively. Last month's salary, which is the salary preceding month of the incident of the victim, was 20,922 after deducting 130 rupees. Therefore, on the basis of three salary slips, Learned Tribunal assets monthly income to be rupees 20,922. The question is whether these salary slips were
They were there. No, they were, the employer came to prove
No. No. In fact, these alleged salary slips were not exhibited before the Learned Tribunal.
So gross income, okay, gross income. Okay, the three.
My lord, then my lord,
December 2018, January. Okay, November, December and January. Accident took place?
Accident took place, my lord, on my lord,
2019, your lord.
19 month 6th February 2019.
That was February.
February 2019. Then your lordship kindly come to page 32.
Page 32.
Page 32. Page 32, like in page 3 of the award.
Yes.
last but one paragraph from bottom. Sentence starts to prove. Last
Yes.
but one paragraph from bottom. To prove the petitioner's case, the petition number one, namely Chandana Sarkar and one Ganesh Sarkar. Chandana Sarkar is the widow of the deceased, and Ganesh Sonar is the one of eyewitness.
So these exhibits were marked without objection or with objection?
Well, not marked.
No, it's stated here exhibit 1 to exhibit.
Yes, yes. Well,
How is that? Okay, I have to see the trial court records
yes,
then.
yes, kindly.
Let me see. Hey, record the trial court records.
Page 10. State-wise page 10. Page 10. The deposition of widow. Hello, you got it, my lord?
Yes.
Page 10. Exhibit document
Trial court record the exhibit documents.
Page 10, you will find that deposition of PW1.
No, these are documents, exhibited documents.
Yes.
Okay, just a minute.
Salary slips were not exhibited. It was marked as the identification. Because employer did not, the claimant failed to produce the employer before the learned tribunal.
Okay, देखिए येटा deposition टा.
Exhibition kindly come to kindly see the deposition of PW1.
Okay.
Chandana Sarkar Malat, chief.
PW1.
PW1 chief.
Order. No, not order.
Not order.
Okay. So exhibit 1 to 8 is proved. Let us see exhibit 1 to 8.
1 to 8 is proved. Then
let us see exhibit 1 to 8.
Yes. These are all FIR, charge sheet, scissor list, insurance policy,
exhibit 1,
voter ID cards,
exhibit 7. Okay. Okay, salary slips were marked.
Exhibit X for identification. Without making the salary slip as marked exhibit, the learned tribunal relied upon those salary slips. That is my challenge. It cannot be.
Yes, anything else?
Your Lordship, kindly come to that way. Kindly, Your Lordship has gone to the that 3 alleged salary slips. Kindly come.
No, it is there. Okay, salary.
There. Yes.
So the question is, it is not exhibited.
Not exhibited, and also
yes,
the manufactured one. Why I am saying, Your Lordship will find signature of the employees column. Bottom. Signature of the employee column. Blank. All three salary slips. Signature of the employee bottom, because it was manufactured after the death of victim. Signature was not there. In the salary slip, signature of the victim must be there. If the column is there, the signature must be there.
Okay, what is the cross examination with regard to income?
Income are denied.
Okay.
No deny.
Denied.
No deny.
In fact,
okay.
Whether denied or not, that is not the main case. Whether your salary slips were exhibited or not, that is the main thing. It was not exhibited. It was not proved. Your
No,
avocation
in the claim case, what is the compensation claim? Monthly income stated?
monthly income stated, my lord, 2152.
21.52.
2150, because it was well, after manufacturing, well, this claim case was filed.
No, as per this documents, it is 16,000 something. In the affidavit in chief, it is stated 20,052, 21,000.
Yes.
Any certificate issued in the
No.
okay, in the name of the company?
No, nothing. Nobody, no certificate, nothing, no document. Employer has not been brought before the learned tribunal, nothing. A three slips which can be manufactured.
Okay, but any certificate that
No.
the employer has issued?
No, nothing. These only three alleged.
Okay, this is the documents just. Rockwell's.
Only three. It can be manufactured. It's a computer
Okay,
generated.
employee name Deepak Sarkar.
Yes. And I'm putting this question on myself, where the signature of the employee? The victim's signature is not there because it was manufactured after his death. That is the victim's signature was not there. Without
Okay, employer's name is mentioned in this claim petition?
Yes.
Mentioned. Employer name mentioned. That doesn't mean that person was the employer of the victim. Until unless the employer come before the learned tribunal.
No, is there anything in the cross examination that so and so is not the employer?
No, there is no cross examination because the employer has not put to the dock.
Very well. So far, she has stated so and so is the employer, such is the income. Any cross examination?
No, because when she was adducing evidence, the insurance company doesn't know whether the employer will come or not. That stage, after that, it was found that no employer had not been adduced before the learned tribunal. My humble submission before Lordship, that is twofold. Either your Lordship kindly do not consider that LS slip and fix notional income. Elsewhere, kindly remind back the matter before the learned tribunal to prove the above income.
Trial court considered 16,000.
Trial court considered 21,000.
21?
21,000 last month income.
That is last month's income.
Yes.
Yes, what do you say?
PW1, my lord. Page 11. Cross examination has been done. Totally agree. I filed the document to show at cross examination, my lord. I filed the document to show that my husband was employee under Rocket Research in Earth Mover Limited and he used arms. He used to earn 21,052 per month. Already admitted in cross examination, my lord. This is the question as they are.
Where is that admitted? Admitted by the widow, not by the.
And he wrote cross accusation, not by the witness. Page 27, my lord. Stamp and payslip already stamp and signature there. Page
But what
27.
prevented you to call the employer?
I several times attend, my lord. Not come here there. Record is speaking itself, my lord. Page 27, my lord.
So you could have enforced the appearance.
Yes, my lord.
Where is that order? That
Recent the Supreme Court judgment. No records.
no. Where is that order? Let me see that you have issued someone.
May 20.
Yes.
Page 20. Para 20. You can see
Let
that.
me see the record that you had issued, so that the someone was issued to the employer and he did not turn up. Which order?
Order is speaking itself, my sir. Several order is there. You can see, my lord.
Let me see. Let me
Let
see.
me.
Okay, for evidence in chief. First of all, PW1 was examined.
PW2 examined.
PW2 eyewitness.
PW2 examined. Where is the someone issued to this thing? PW3. You see, if this case is to be accepted without exhibiting documents, then in all case, this has to be accepted. Very well, let me see the order. Very, let me
see. Para 20, my lord. Para 20, my lord.
A copy in unreported দেখুন
Para 20, my lord. Easily, without exhibition, can be done it.
No, this was marked exhibit.
No.
What it stated, in view of the, we did not that the, while rejecting the salary certificate exhibit 19 and pay slip exhibit 20, that means it was marked with objection or whatever it is, it was marked. But the court did not accept it.
My lord.
And you see,
exhibit,
these were corroborated by the statement of the deceased wife here also,
yes,
and his co-workers. Did you bring any co-workers?
My lord,
Either employer or co-worker?
my lord, this is Kindra. The documents are not examined. The two documents are not examined, my lord.
These two documents were marked exhibit,
Yes, my lord.
but the court refused to accept that as because the employer was
Yes.
not examined. But the Honorable Apex Court stated that this is corroborated by the deceased wife and his co-workers. Had there been some co-workers also, yes, it could have been accepted. Okay, I shall consider it.
My lord, this is the judgment, my lord. Supreme Court, only documents are enough.
Let me see this.
Pay slip stamp is enough.
My lord, kindly grant me 30 minutes. I shall produce 1,000 number of this type of salary slips.
No, 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 no.
It can be prepared.
Let me see. Okay. Yes, learned advocate for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 24/7/2026.